Right on time. On juvenile justice and family issues will come to order. Clerk will call the roll.
Chair Dutton.
Here.
Vice Chair Lujan. Representative Cook.
Here.
Representative Wilson. Representative Lopez.
Present.
Representative Martinez Fisher. Representative Smithy. Representative Tallarico.
Here.
Representative Wu.
Here.
Quorum is present.
A quorum is present, members. Let's see, we'll go ahead and get started. What are we doing?
2360. 2360.
Okay, the chair at this time lays out House Bill 2360 and recognizes its author, the Honorable Sanfonia Thompson.
Mr. Chairman and members, thank you so much for letting me lay this bill out. All of us are aware of the most dangerous time for a victim of family violence is when they are leaving an abuser. So doing so requires a detailed plan to find and maintain a safe place where the abuser cannot be located. Under current law, protective orders, applicants are required to disclose their county of residence on the application, which may inadvertently inform an abuser of their whereabouts. This bill allows a court to maintain the confidentiality of the survivor's county of residence. The court and the law enforcement would still be delivered a separate confidential form that is entered into law enforcement database, ensuring they have all the necessary information to ensure the protective order. At this time, I'm available for questions of this wonderful committee, Mr. Chairman, and I would like to request the right to.
Are there any questions
close.
of Ms. Thompson, members? Not hearing any. Show Mr. Martinez Fisher present. And we will open up public testimony. But before I say that, anybody who intends to testify, you need to register first at the kiosk outside. If you haven't done that already, please do that, because when you come up to the lectern here, you need to tell us your name, whom you represent, and your position on the bill, and then you may proceed to testify. With that,
Where's your computer?
I don't know. I have no idea what happened to it.
Yeah. Her name is Heather Bellino.
Well, I can't see that.
I know, that's why Heather Bellino.
Can you pull it over here?
Yeah.
Okay. I can't read that far. Heather, the chair calls Heather Bellino. Saying that right?
I can't read that far either. That's why these are working well.
Well, they got small letters.
Well, thank you for having me, Chairman Dutton, representatives. As you said, I'm Heather Bellino. I'm the Chief Executive Officer at Texas Advocacy Project. And I am here to speak on behalf of the survivors we serve and the attorneys that work so closely with them.
And are you representing?
Texas Advocacy Project.
Okay, thank you.
And so, as I said, Texas Advocacy Project provides free civil legal services and social services for survivors of domestic and dating violence, sexual assault, stalking, human trafficking, and unfortunately, often child abuse. We work with members of the judiciary, we provide trainings and presentations, and we've been doing this, as I said, for over 40 years. As Representative Thompson said, when survivors of domestic violence apply for protective orders, they are required to disclose the county of residence on the application. However, once that application is completed, it is served directly to the abuser, and the county of residence is on that piece of paper. So this practice, it unintentionally puts a survivor and their children at risk by disclosing their whereabouts to their abuser. Now, it seems like a county is a vast enough expanse where it would provide sufficient coverage for a survivor, but oftentimes the survivor has been living with their abuser or has known their abuser for a long period of time. And so that abuser knows where their family lives, knows where their best friends are, their college roommates, somebody they went to elementary school, the person that they might go in hiding with. So once you notify that abuser of the county, it triggers all those locations that they know that the survivor might be staying at. So confidentiality is really essential for survivors of domestic abuse because it provides them with that secure way to protect their location from their abusers. I can tell you that we had a client that as soon as that application was handed over, they knew that she was in another state at her mother's house. Immediately, he started calling all of their friends saying, have you seen her? Is she hanging out in the local spots? Before that protective order was even issued, she was in danger, and so was her family. So survivors who flee their abusers, as I said, are at high risk of being found and harassed. So by removing that requirement on the application to publicly disclose their county of residence, survivors have just that little bit longer to flee to safety. So they can be rest assured that their sensitive information will remain confidential, and therefore the safety of them and perhaps their children will be secured. So SB 578 and HB 2360 offer valuable support and resources to survivors of domestic violence, providing them with a sense of relief, that chance to get into safety, that chance to get their friends and families and their support system in place before they do have to go in front of a judge and go through the entire justice system. So we're just asking for a little bit more time for them. So that is what we're here for, and this legislative measure plays a crucial role in helping the survivors. So thank you for your consideration.
Thank you. Any questions of this witness, members? Not hearing it. Not hearing any. Thank you
Thank you.
for being here. Is there anyone else here who would like to testify for, on, or against House Bill 2360? Not hearing any. Chair recognizes the Honorable Symphonian Thompson to close.
Mr. Chairman, members, I close and thank you.
All right, thank you. It's the chair's intent to leave House Bill 2360 pending before the full committee without objection. Chair hears none, so ordered. Okay, the chair at this time lays out House Bill 4183 by Chairman Price and recognizes the author.
Thank you, Chair Dutton and committee members, for allowing me the opportunity to bring up House Bill 4183. I appreciate very much, Chair Dutton, you hearing this bill, because one quality of yours I've always admired is a sense of fairness. And that's what this bill is about. As you know, Justice of the Peace can perform marriage ceremonies in Texas like many other judges, but unlike other judges, the Family Code does not provide legal authority for a JP to consider and enter a written waiver permitting the marriage ceremony to take place during the 72-hour period immediately following the issuance of the marriage license. In order for a Justice of the Peace to perform a wedding within the 72-hour time period, written approval must be obtained in the form of a written waiver from a judge of a court with jurisdiction in family law cases, a justice of the Supreme Court, a judge of the Court of Criminal Appeals, a county judge, or a judge of a court of appeals. A justice of the peace in my House district, Judge Robert Taylor, contacted me and informed me that justices of the peace have difficulty obtaining such written waivers given the numerous matters, including heavy dockets, competing for the attention of a judge on a court with jurisdiction in family law cases, a justice of the Supreme Court, obviously, judge of the Court of Criminal Appeals, county judge, or a justice of the Court of Appeals. So the purpose of House Bill 4183 would amend the Family Code to allow a justice of the peace to consider an applicant's request for a written waiver of the 72-hour waiting period, provided the JP finds that there is good cause for the marriage to take place during the period and the justice of the peace signs the waiver. In communication, and Judge Taylor could not be here today because he's working. He had written into my office. I thought it was kind of interesting. He makes the point that it's difficult for him to find a judge available to sign the waiver, but he didn't see why it would not be proper and reasonable given that they sign warrants of arrest, eviction, writs, perform marriage ceremonies, and also setting of bonds and conditions and other numerous papers for the court. So, again, it's a matter of fairness. If everybody else can perform the marriage and do the waiver, then that's what this is asking. So I appreciate the opportunity to answer any questions. I'd like the opportunity to close.
Makes perfect sense.
Thank you, Representative Price. Any questions, members? All right, we'll start the public testimony at this point, and give you the right to close. Chair calls Charlotte Bradshaw.
Hello, my name is Charlotte Bradshaw. I'm here on behalf of the Family Law Foundation and as an individual. We support the bill, and feel like it would be very efficient to have this bill so that the JPs can perform those services. We're in the family courts all the time, and they are jammed, and it's very difficult to get a hold of them, anyone. So we support the bill and feel that it would be in judicial economy to pass it. Thank you.
Any questions of Ms. Bradshaw, members? That's okay, Ms. Bradshaw. I think you anticipated there were no questions. Yeah, thank
Thank
you.
you.
Thank you for your testimony. Is there anyone else here who would like to testify on, for, or against House Bill 4183? Chair hears none and recognizes the Honorable Price.
Thank you, Mr. Chairman. I ask for your favorable consideration of this bill, and that if it's to your liking, to send it local on consent calendar.
Thank you.
Thank you.
Thank you. It's the chair's intent to leave House Bill 4183 as a matter of pending business before the full committee without objection. Chair hears none. So ordered. Okay, the chair at this time lays out House Bill 1432 by the Honorable Ms. Mason.
Concerned about that pause between the word honorable and Ms. Mesa, but always good to see you,
I was
Chairman
looking for a
Dutton. I'm
better
used to
word.
seeing you as my chair on Pub Ed, but it's good to
Thank
see you
you.
today as chair here.
Thank you.
And so, Chair and Vice Chair and distinguished committee members, House Bill 1432 is about protective orders. As you know, they're important legal documents to help protect victims of family violence, also covers dating violence, stalking, and sexual assault. But in Texas, to obtain a protective order for family violence, one has to prove that family violence has occurred, fair enough, but it also asks that to prove that it's likely to occur again in the future. Well, this is not the movie Minority Report. We're not able to predict crimes in the future. It's a higher standard compared to obtaining a protective order for stalking, sexual assault, or human trafficking. So House Bill 1432 would change the requirements to obtain a protective order by removing the condition that the court finds family violence is, quote, likely to occur again, unquote. This bill will help standardize the process of obtaining a protective order by removing much of the ambiguity that's in the current code. This bill would also bring the protective order requirements for family violence in with the same standard that we have for stalking, sexual assault, and human trafficking. Requiring victims to prove that family violence is likely to occur again is a high burden of proof that can be difficult to meet, and this requirement can prevent victims from receiving the protection that they need and put them in unnecessary danger. Victims of family violence may not be able to predict whether violence is likely to occur again, especially in cases where the abuser may have a history of violence, but it's not recent. If the requirement in order to get it is say, well, it has to be something that happened recently. In such cases, victims may not be able to meet the requirements to prove that violence is likely to occur again. So Texas is one of only a few states that requires victims to prove that family violence is likely to occur again in order to obtain a protective order. For example, in Nebraska, they have a domestic abuse protection order that's granted because someone attempted, threatened, caused bodily injury, or intimidated the other person by credible threat. In North Carolina, a domestic violence protective order is granted if the defendant initially caused physical injury, imminent serious injury, continually harassed the victim, or sexually assaulted the victim. So in many states, there is no requirement that domestic violence has to be proven to likely occur again. So House Bill 1432 would provide more consistent protection for victims of family violence, make it easier for them to seek the help and the protection they need, and take out what I feel is an unnecessary requirement to prove that it's likely to occur again. And that.
Members, do you have any questions? Okay. And if there are no questions, Chair recognizes Representative Lopez is now present.
She was already present.
Oh, she was present? Okay, well, she's double present now.
Right. So, opportunity to close if there are any witnesses.
Thank you. Chair this time opens public testimony. Chair now calls Rachel Huskin to the stand.
Hello,
Please tell us your name, who you represent, and your position on the bill.
my name is Rachel Huskins. I'm representing myself today, and I support House Bill 1432.
Thank you.
I'm 23. I'm from Waxahachie. I'm a full-time law student. I am a survivor of domestic violence, and I flew all the way from Boston today to gain your support.
Wow.
So in 2020, I met Marcus Garcia. He was Mr. Wonderful. and I thought he was my soulmate, like every 20-year-old girl does. Within a few months, he completely isolated me from my family and my friends. And he kind of started these really stupid arguments, just degrade me, and this escalated into physical and sexual abuse. He slapped me when he didn't like my clothes, beat me when his Chipotle order was wrong, dragged me across the floor while I was doing homework, held a gun to my head when I tried to call 911, and choked me when I screamed for help. And before I go on, if your 20-year-old daughter came home and told you that her boyfriend did that, would you tell her that she would be okay as long as she thought he wouldn't do it again? Or would you tell her to leave? To leave? Yeah. So I didn't stay because I was stupid. I started Googling the things that he would say to justify the abuse, and the first dozen results are domestic violence resource websites. And I learned that having a firearm in the home increases the odds of death by 500%. Strangulation increases it by 750%. And then 77% of domestic homicides occur upon separation. At this point, I stayed because I knew he was not going to change. And then 6 weeks after he moved out, he started blowing up my phone, threatening to show up to my apartment. I filed for a protective order the next day, and I testified to 21 different instances of physical abuse, sexual abuse, stalking, and threats. The judge's exact words were that there was a wealth of evidence of family violence, but she denied my application because there was no evidence of likely future family violence. So I appealed it. I was working as a paralegal, and my boss agreed to take the case. And there is a very big downside to being the paralegal on your own case, so that you don't have a lawyer to use fancy words to give you false hope. So you know that appellate courts are very unlikely to overrule trial court findings. And as expected, I lost for that reason. And I'm not here to say that that's unfair. I'm here because I used social media to speak up while I had the protective order, and because it made me feel safe. And I'm in law school because I still have faith in the system that failed me, and I want to help the next girl who spends her 21st birthday in the floor of her closet while a man stands over her. But I can't do that if the law does not let me. And I know that Representative Meza brought up the sexual assault protective orders. There was a Harris County study. 68% of Texas women who were physically abused by their partners reported forced sex at least once. 79% reported repeated episodes of forced sex. 78% of victims have been stalked by their abuser. And intimate partners are involved in 91% of forced sexual exploitation cases. So there's no reason that this it should be harder for the all-inclusive victims. And the current findings were enacted in 1979. That is 10 years before it was a crime to beat your wife in this state. The only change is that it no longer says foreseeable future. But it needs to happen, and if you would tell your own daughters to leave, then you should not let a judge be able to say that she should stay, or she would be okay, as long as she thought he wouldn't do it again. So.
All right, thank you for your testimony. Any questions? Representative Wu.
No, thank you, Mr. Chairman. And I really want to extend our sincere appreciation for you taking your time to come while you're in law school and to testify to this. I know this is a difficult subject matter, and before, when I was in grad school, I volunteered in actually the Safe Place here around Austin, and I've actually heard the story many times. Lots of people, men and women who beat themselves up and saying like, it's, I should have done this sooner, I should have left sooner, and feel like it was their fault. And I want to make sure anyone who's listening that it's not your fault. That part of the abuse is the manipulation to keep you there.
Well, and that is one thing that there have only been 3 appeals for victims who have had the second finding
Yeah.
denied in the state. And the reasoning that the trial court uses is never
Right.
really right. There was one that they seriously said these are grown people we're talking about here. And so it kind of lets the courts get more involved into the relationship
Right.
than they need to be. And
Yeah.
it needs to be about, is this person a victim of a crime? And having that order in place, regardless from physical protection, it's protecting your voice, your right to speak up, and it encourages people to come forward, and nothing will ever change if we don't encourage that. I
Appreciate that.
appreciate it so much.
Thank you.
Any further questions of this witness, members? Not hearing any. Thank you, Ms. Huskins, for your testimony. Is there anyone else here who would like to testify for, on, or against House Bill 1432? Not hearing any, the chair recognizes the Honorable Representative Mesa to close.
I feel fairly confident that the committee joins me in thanking her for coming to testify. It's important when we can have a person give their personal story and their face to a bill that we're considering.
Yes.
Too often, our homes should be our safest place in the world. And for many women, it's the place where we're the least safe. So I appreciate your consideration of this bill. We just need to strike the phrase about likely to occur again. So I hope that you'll respond favorably to this one so that we can take that out of the law.
All right,
And we can
thank
get
you.
more women. And it doesn't just happen to women. I mean, we think about women mostly, but it happens to men too, that they can be protected. Thank you.
All right. Any questions of Ms. Mesa, members? Not hearing any, it's the chair's intent to leave House Bill 1432 as a matter of pending business before the full committee without objection. Chair hears none, so ordered. Chair lays out House Bill 2091 and recognizes its author from Beaumont.
Good afternoon, Chairman and members. Thank you for the opportunity to present this bill today. HB 2091 seeks to amend the Family Code by allowing an applicant to keep their information on an informal marriage license form confidential by checking a box. Currently, when individuals applies for informal marriage license, both parties' full name, address, the last four digits of their Social Security, and county is available for public viewing. Such details are not available for regular marriage license. This information is easily accessed with a few clicks of a button on the internet. The privacy of an individual is at risk, and especially for those who are victims of a crime. It is my belief that this bill will allow individuals an additional means to maintain their privacy. Also, HB 2091 will instruct the county clerk to not publish information publicly or release a copy of the applicant's application or license that contains personal identifying information of either applicant if the applicant checks the specified box. The print box will say if either the applicant name on this form is or has been a victim of family violence, dating violence, or sexual assault, stalking, or human trafficking, and would like the identifying information on this form to be kept confidential. And then that way they'll be able to check the box. We don't anticipate a committee sub at all on this one. This is, of course, I think all domestic violence and sexual assault is personal because we know it touches everyone. But I had someone in my district who this is how their offender was able to reharm that person by being able to pull up that information that wouldn't have been pulled up on a regular marriage license. I think we have a subject matter expert if anyone has any questions on it, but I reserve the right to close or any questions for you all.
All right. Any questions of Mr. Representative Manuel? Representative Rue?
Thank you. So the legislation just makes it these informal marriage certificates the same as the regular marriage certificates.
It gives an option for a person to be able to check that to say, yes, I've been a victim of in any form of family violence, domestic violence, sexual assault, human trafficking, to be able to check that box and just to have that information redacted like it is with a regular marriage license.
All right. Any further questions? Well, thank you. We'll give you the right to close. Let me check if is there anyone else here who would like to testify for or against House Bill 2091? Not hearing any, Chair recognizes Representative Manuel to close.
Thank you again, Chairman and members of the committee. I think this is a wonderful bill. I think this will add protections, and I appreciate you all for taking the time to let me lay this out, and I'll go ahead and close.
Okay. It's the chair's intent to leave House Bill 2091 as a matter pending business before the full committee without objection. Chair hears none, and so ordered. Chair at this time lays out House Bill 2094 and recognizes its author, Representative Manuel.
Hello, Chairman and members of the committee. I am back again really fast. The goal of HB 2094 is to provide a victim of family violence an opportunity to have a safe place during a divorce proceeding. This bill's purpose is that while a suit of dissolution of a marriage is pending, if one of the parties has either during the pendency of the suit or in 1 or 3 year period preceding the date the suit will be filed, has been convicted of or has been placed during deferred adjudication, community service, or for felony offenses. This bill is going to be something that it'll be happening during the divorce proceeding. HB 2094 is to assist in the separation of victims from offenders when there is a recorded history of family violence. This bill does not take away the judge's ability to make a decision of what happens to the residents towards the end of the divorce. When there is family violence, the fear and risk and danger is heightened, especially when the abuser has access to a home. And when an abuser has equal access to the property, it provides opportunity for that person to further intimidate and manipulate the victim. An unfortunate statistic is that it is hard for victims to leave their abusers and often do tend to return to the relationship. A divorce can take up to 6 months or longer, depending on the complexity of the case. Additionally, to other victims, this would give them resources to be able to feel more protected. We do anticipate a committee sub on this. The committee sub will say primary.
Hold on, Mr. Representative Manuel. Chair at this time lays out the committee substitute to House Bill 2094 without objection. No objection. And recognizes the author to explain it.
The committee substitute for 2094 the committee substitute will identify the primary home as the one to be awarded. This is in the case that there are multiple residences. Moreover, we've added language for victims to opt out of this order. This is in case they choose not to stay in the primary residence or if the victim and offender come to an agreement. This is just kind of to make sure that during these kind of separations, when there's family violence, that the person who's being abused, the children, if there are children, have a safe place to go so that we don't have to uproot everyone's life. Because currently, right now, if you're in an abusive situation, a lot of times the person who's being abused is the person who stays. And so is the one who leaves. And so we're just trying to make sure that we're protecting families, children, and people who are victims of these kind of sad and horrible situations. With that, I'll reserve the right to close, or unless there are any questions for me.
Let's see if there are any questions. Any questions? I think Representative Cook has a question.
Thank you for bringing this bill. I guess my question centers around your intent with regard to whether or not the property is a separate property of either party.
So what this is, it'll be kind of like wherever the primary residence is that a person is staying. So this is right now wherever the person or persons who are living together, that primary residence would be the place where that person who's being abused wouldn't have to leave.
Okay. Doesn't the court have the discretion to do that today?
Well, yes, a judge can make that order, but this would make it automatically that if you have committed felony assault, that automatically the person who's the abuser, because that's why it's the 1 to 3 years, to show that there's been proof of a history of family violence by one person onto another.
But again, so you don't, in your bill, it doesn't preclude someone losing their separate property or losing the use of their separate property. Is that correct?
As of right now, no. This is just giving them the opportunity to stay in the residence.
Okay.
We're not taking the residence from anyone at this point, unless this is still going to go through a proceeding, but so that whoever, and I don't want to, like, again, say that it's just men or women, but whoever's being abused in that situation would not have to leave, but they can always come to an agreement. A judge still has an order to do this. This is just putting that added protection to give people the option to know that they can leave an abusive situation and not have to completely uproot. And this is from more of a personal level. Like when my mother had to leave an abusive marriage, we all had to leave while he stayed in the home.
Sure.
And so then you have to move schools and all that.
But I guess to me, it makes more sense for a judge to hear facts on that, you know, what the facts are in that particular case that you're describing. That
Okay.
I would have confidence in a judge making the right decision. But again, that's my concern is depriving someone of the use of their separate property.
I completely understand.
Because if you're talking about. I do applaud you for making it where it's a marriage. I mean, not as opposed to a
Correct.
situation where it's a
Yes.
dating relationship and you're depriving.
Yes.
And,
I think that would be too excessive, yes.
thank you.
Thank you.
All right. Show Mr. Representative Smithy present. Let me ask you a question, though,
Yes, sir.
Emmanuel. If the house where the person has decided to stay, if it has a mortgage on it, is part of your consideration of the bill has to do with whether or not who pays the mortgage or anything?
No, whoever would end up being in the primary residence. So let's say, for instance, during these proceedings, and again, just for a little clarification for me, I'm going to say let's say there is the abused person decides to stay in the home, they would then, at this point, they would be responsible for having to cover the mortgage, or if they choose to sell it. If they decide to come to an agreement where the person who was the abuser decides to have it, then they would have to take up the mortgage. But if you would stay there, it would be like if you have to get an apartment, you still have to pay rent. You would still have to continue to pay the mortgage if you chose to stay there.
So it's your idea that, your intent that whoever's occupying the residence would pay the mortgage?
Yes, sir.
Would the judge have necessarily any discretion to decide that issue?
The judge can still decide if they want the other person, of course, through divorce proceedings.
Right.
They would choose that. Yes, sir.
Okay. All right. Any further questions, members? I think Reverend Cook has a question.
Well, I just think it's a great question that you asked, Chairman, and I don't see anything in the bill that speaks to. That may be the author's intent, but there's definitely nothing in this bill that
Okay.
says that the person living in the residence would be paying those expenses.
Okay, and I would love to clarify that in the bill for sure.
We'll get with you on it. Any further questions of Representative Emanuel, members? Not hearing any, thank you. We'll give you the right to close. Let's see if there are any witnesses. Is there anyone else here who would like to testify for, on, or against, what number are we on?
2094.
House Bill 2094. Not on, for, or against. Not hearing any. Chair recognizes Representative Emanuel.
Thank you again, Chairman, members of the committee. I will go ahead and close, but before that, I'll say I'm so happy to have so many free attorneys to make this better, so I appreciate you all so much. Thank you.
All right. The chair withdraws the committee substitute to House Bill 2094 and leaves House Bill 2094 as a matter of pending business before the full committee without objection. Chair hears none, so ordered. Chair now lays out House Bill 2095 and recognizes its author, Representative Emanuel.
Hello again, Chairman and members. HB 2095 seeks to amend the Family Code by requiring the court to further inform parties on what restrictions apply to their protective orders, otherwise known as POs. This bill will address the issue of the applicant being properly informed about the restrictions that may be available whenever they file for a protective order. The purpose of this legislation is for the judge to provide the party applying for the protective order with descriptive information in reference to the restrictions provided in the protective order. When a victim is filing for a protective order, they are not always assisted with legal representation. Protective orders are normally needed immediately, and often victims do not have the time or resources to obtain representation. However, they do have a choice to file a pro se. This may leave room for vulnerability as they are sometimes unknowledgeable regarding the specifics of the legal language. Most importantly, it is common for the applicant to freeze up and get nervous during the actual proceeding. Their words may be fumbled or the victim may not be able to focus and may become confused because they are expected to act as their own attorney. An additional obstacle is the language barrier. Family violence does not discriminate in constituents, or any constituent or any background, and they all have rights. Judges have the discretion to apply the restrictions to this application. For example, a judge may only agree that the offender may not harass the victim and leave the actual distance restrictions. This bill requires the judge be clear with the applicant and specifically discuss local restrictions, and it allows the victim to specify their wishes regarding the restrictions. This is to help minimize any assumptions and allows for the most important components of the protective order to be clearly verbalized. I do not anticipate any committee subs at all, and one area that is great, and especially for us in our rural areas, we oftentimes, there's not a lot of legal representation. We know that some people have court within their homes, so this is going to add, in my opinion, some clarity to making sure that when people are getting protective orders, they know exactly what their protective order is giving them and gives them the tools and information to be able to protect themselves. And if there are any questions, if not, I'll reserve the right to close, Chairman.
Any questions of Representative Manuel, members? Not hearing any? Okay, let me see if there's anybody is there anyone here who would like to testify for, on, or against House Bill 2095? Chair sees none and recognizes Representative Manuel to close.
Thank you so much, Chairman and members of the committee. I appreciate it, and I close.
All right, thank you, Representative Manuel. Chair's intent to leave House Bill 2095 as a matter of pending business before the full committee without objection. Chair is none and so ordered. Chair at this time lays out House Bill 730 and recognizes its author, Chairman James Frank.
Thank you very much.
There is a committee substitute. Chair lays out the committee substitute to House Bill 730 without objection and ask Representative Frank, Chairman Frank, to explain it.
Yeah, thank you very much, Chairman Dutton and committee members. Really appreciate the opportunity to speak with you all today. It's not a simple bill. Always laugh because that's always the first thing somebody says. Simple bill. It's not a simple bill, but I think it is an important bill. So I'm going to lay it out for you. It's really to revise the practices of DFPS when they are in the investigative stage. I think we've done a lot of important work over the last number of years on this, and this is something, honestly, that we worked on several years. But it's to really change and improve, I think, the way they encounter parents and the discussions between parents and them. So what the bill does is three things. First, the hidden foster care system. It's hidden. Most people don't even know about it. There have been as many as 90,000 kids. Now there's about 10,000 kids that are in foster care, and you don't even know it. They are in parent-child safety placements. So they have been forced out of the homes, but they're not under the purview of a judge. They're really not even under our purview because there's really no legislation around it. So what this does is basically put very tight 30 days, then 30 days, and 30-day time frame on the parent-child safety placement. I really believe long-term that we need to move where any removals are under a court order. That's not what this does, but this does put tight time frames if you're forcing a child out of the home. So that we don't lose them, because sometimes if they're not in the system, they're not in the system. And shockingly, they do get lost. The second thing is a notification of rights. It's in a verbal and with enforcement that you must notify them of their rights, the right to remain silent, assistance, that they have a right to assistance of counsel for court-appointed counsel if indigent, that they have a right to record what's going on. We've had plenty of times where they said you can't record what's going on, which is honestly, I think, a little dangerous. And you can read the rest of them. I think it's almost as important, I think, that our investigators are verbally reminding themselves what the rights of the parents are as much as it is the right of the parent to hear it. But I think, and then the last two parts that it does is there has to be probable cause of abuse or neglect in hearing to obtain the order. It must be ex parte unless it is to protect safety of the child and time doesn't allow for it at future hearings. You can do it, but you have to have good cause. And the last is that the ex parte hearings have to be recorded. I do want to thank, we've had a lot of people working on this during the interim. I'm just going to read through them, but Text Protects, the National Association of Social Workers, we had basically groups meet really about every other week for months going through this. Texas Association of Family Defense Attorneys, Family Freedom Project, which is actually the Homeschool Coalition, or the same group. Texas Family Law Foundation, Texas Public Policy Foundation, Parent Guidance Center, the Texas Alliance of Child and Family Services, Texas CASA, Griffin Law Firm, Judge Mike Schneider, and One Accord for Kids. And then, of course, we have opportunities for the free lawyers. I thought that was a great comment. We have opportunity for free lawyers to weigh in on it here. It doesn't mean it's a finished product, but there has been a tremendous amount of work on it. The last couple things I just mentioned. I will be addressing the fiscal note. It was actually really confusing. In one place, it says this is going to cause less kids to be in foster care, and therefore, but we can't determine what it is. And in another place, it says it's going to cause more kids to be in foster care. So I think that is an inconsistency in the fiscal note. I will address it. We'll either get the money in there to take care of the fiscal note, or we'll make some changes in the bill. It's kind of funny. I think the main reason is because of the information that we're asking for requires some system changes. But asking for information on kids that we have forcibly removed from home is not, I don't think, an unreasonable request for legislators to make, because it is not okay, as the chair of the Human Services Committee, to not be able to get information on how many kids we have out there in that hidden foster care system. And so, anyway, with that, I would be happy to answer any questions, and we do have some of the folks that participated here to answer questions as well.
Does the bill make it more or less difficult to remove a child from the home?
I would say it makes it more difficult. It makes it a more consistent process and a more transparent process. If you recall, last session, by the way, through this committee, I know 3 of y'all at least were on there. I know David, Representative Wu, we passed 567, which actually addressed the definition of neglect. And because of that bill, honestly, we have had a pretty significant reduction from, there were about 30,000 kids in foster care. Now there's under 20,000 kids in foster care. The removals have dropped by about 30%, 35% removals because of the definition of neglect changing. Make sure it's an immediate danger.
And
I don't think this makes it, this is my opinion, other people can have differences. I don't believe this makes it materially harder to remove. It doesn't change the standards of removal. It simply says you are going to notify people what their rights are up front. And again, people may disagree and say, well, if you notify them of their rights, we're not going to be able to remove children. I personally don't think that's the case. You guys, Representative Wu obviously deals in this directly. He may say it does, and I don't know. I don't believe it does.
All right. Representative Wu.
Yeah. No, I appreciate it. And I was a joint author on 567 because I liked what that did, and part of the objective back then was to get rid of some of the cases that were kind of sort of on the edge of like whether this had really been a termination case or not, because unfortunately, like a lot of those termination cases, even though they're sort of on the edge of should we follow these or should we not, but sometimes people progress on those cases. They might hit or they might miss, and they end up having their kids taken away permanently.
Yeah, they don't do a service.
Right. But that's still, that was what happens in a court process. And so what I had envisioned under 567 was that a lot of those kids that we would have normally removed and set it on the termination track, that they would go instead to like FBSS and have the family, have the parents do services out there without the threat of termination hanging over their head, right?
And we do have an additional pilot program that is doing that, actually trying to provide, because a lot of these kids, some of the kids could be safely left in the home if we had services. And we have a pilot program set up to try to do that. The only problem I have with the parent, or not the only problem, but the primary problem I have with the parent-child safety placement is there is zero court oversight. And so we set up a pilot program in 4 of the regions to try to allow judges to keep the child in the home, but they could start the removal process, but you actually have them in the home in a supervised way. Now, that is taken off very slowly for a number of reasons we can get into later, but we are trying to work that direction, and I totally agree with you on that.
So, and that's kind of like where I'm a little bit torn on this bill. I understand what you're doing, and I think some of the rights are things are good, important to know, and important for people to have. I mean, as an attorney, I'm very happy when people are told, "Hey, you don't have to talk." I would love it if my clients would talk less. But my concern, one of my big concerns of that is that CPS is reactionary. Like they basically, I feel like a lot of times they do what they feel like they have to do, and so if we're taking all these kids after 567, we're taking all these kids, like almost 10,000 kids that did not get removed, right? And there's no termination case started on them, and if we're pushing those to FBSS, but FBSS and child safety placement plans become harder to do, and they become more limited in usage, then those kids are CPS is gonna say one way or the other, we're just gonna start termination case on them then. Because like a lot of this stuff is subjective. Like a lot of the ways, the way these terms are defined and the way these things are looked at can be subjective. And
I think that's what I'm sorry.
No. But I think there is a not unreasonable possibility that by dramatically limiting what is able to be done in FBSS, that it encourages then say CPS goes, well, we don't have another option. Let's just go ahead and remove them and do the termination. Yeah. Start the termination petition.
So I don't think with the definitions that we gave last year, and I think last session, we refined them and we made them much less variable. We removed the vagueness of those terms. So I don't think that will happen. I will say, and the resource witness, if you choose to call them with the agency, may be able to tell you what has happened with the parent-child safety placements, but separate and apart from legislation, they have greatly decreased their use of safety placement because I think they understand if you're forcing a child to be removed, you're not providing, and you have no court oversight, that is a dangerous thing. And I am all for, and that's not in this bill, but I'm all for trying to come up with, and really have for my pilot program, try to come up with a middle ground. I just don't think that middle ground is an unsupervised, no court oversight parent-child safety placement. I want something else.
Well, and that's what I mean. And the court oversight, I completely understand your concerns on that. But sort of in my practice world, we barely have enough time to deal with the existing termination cases, and if you throw in the FBSS cases in there as well, if they're throwing it in for oversight, not sure what the docket's going to end up looking like.
Well, from a docket standpoint, if you put all of the parent-child safety placements on the docket, you'd be back where you were 2 years ago.
Yeah,
from a volume standpoint.
And we were trying to get away from that.
Right.
Well, I mean, the thing is, I certainly don't mind if we have reports on accountability, like this is what's happening. And if there's a problem, we can go to the judge. But for every FBSS case to be reviewed and staffed and contemplated by a judge, I'm just saying that's a lot of work. And
right now we should have plenty of time to oversee FBSS cases. The caseload right now is one caseworker for every 5 children in FBSS. If we can't oversee it really tightly right now, we never will be. 1 to 5. It's a pretty nice caseload.
Right. Any further questions?
I'll save the rest for the resource witness.
All right. Any further questions of Chairman Frank, members? Not hearing any. Chairman, we'll reserve the right to close for you. We'll do that. The chair calls, we'll start the public testimony now, and the chair will call Cecilia Wood. Show Representative Leo Wilson present. Chair calls Cecilia Wood. Going once, twice, 3 times. She was testifying. But I needed to read what she was here for. She was testifying for herself and for the Family Freedom Project in favor of House Bill 730, and we will show her as registering for it, but not testifying. Chair calls Carrie Wilcoxon. Okay.
I'm so nervous, I thought I was gonna go last. Good afternoon, Chairman and distinguished committee members. My name is Carrie Wilcoxon, and I am testifying today representing myself, and I am in support of HB 730. I'm testifying today before you as a former child abuse and neglect investigator for the department. I worked within a night unit that handled child death cases and Priority 1 abuse and neglect cases. After I left the department, I then got involved in DFPS legislative reform work, and I've been doing that for about a decade. And I now own a business in where I provide CPS case consultation services to parents and attorneys throughout Texas. HB 730, in my opinion, is overdue. I think it's something that we should have done a long time ago in terms of providing a balance between the power of these case dispositions, the impact of these case dispositions, and the notification process of those rights to individuals who are the subject of a CPS investigation. Right now, the department is required to provide an information manual to somebody that is the subject of a CPS investigation, and that's served up as a very soft information pamphlet. It's titled A Parent's Guide to a CPS Investigation. It's not titled Your Rights While Under Investigation or even Critical Policies and Procedures of a CPS Investigation. And so it's inconsistent. The information manuals that we're putting out there have this soft, gentle tone to it, while the case dispositions themselves are hefty. And I know some of you all are attorneys, and I know that some of you understand how those case dispositions can be used and how they can affect an individual's life, from their livelihood to imprisonment to custody to adopting children. And so this particular bill, with its verbal and written notifications, are going to tighten up that notification process, and it's going to be able to provide a very transparent and straightforward and diligent method of notification of an individual's rights prior to a CPS investigation. As a former investigator, and as somebody that has done a lot of legislative reform work and provides CPS case consultations to parents, most of my clients are indigent. I want to go on record saying this. The department is probably the most powerful entity in this state above law enforcement. I cannot think of any other entity that has the power that it has when it comes to removing children. A lot of parents would tell you that they'd rather risk losing their freedom to imprisonment than losing their children. And so I think this bill is building in some due process that's very necessary around the notification process. And so I ask for your vote on this on 730, and I appreciate your time on this.
Any further questions of this witness, members? Not hearing any. Thank you, Ms. Wilcoxon, from being here. Chair calls Andrew Brown.
Good afternoon, Chairman Dutton, members of the committee. My name is Andrew Brown. I oversee child and family policy for the Texas Public Policy Foundation, testifying in support of House Bill 730. I was going to address two sections of the bill, but I think I'll limit that now given the time and some of the great questions that Representative Wu asked to the hidden foster care portion of the bill. This was actually a topic of considerable discussion among the work group, many of the questions that you raised. And one of the things that I wanted to clarify is that the way that the reforms around the PCSPs have been written into this bill does not necessarily mean that cases will get to a court. It just puts time limits on these cases before DFPS would need to go to a court. The way that that bill is written is if the case goes past 90 days, the informal agreement between the parent and the department regarding placement outside of the home or some type of supervision, if that's going to extend past 90 days, at that point, DFPS would then need to bring a court in and say, we need to keep going on this, whether it's through a 264-203 court-ordered services case, or in certain circumstances, if they can't get things addressed, you might have to escalate to a removal. So really all this is saying is you've kind of got this 90-day limit before you need to do something else. I actually like to think of this section as creating a stair step, which is really in keeping with what we know about the trauma of removal, but also how do we get services to families. You know, we really want to make it as easy as possible for families to access services without the fear or the threat of removal. And so when you have a situation, and really PCSPs were designed for these low impact cases or these low risk cases where we don't necessarily need to go to removal. And so by putting some more guardrails around it, you actually make it more likely that you can continue to use this tool. It's an important tool for the department to have. We don't want to get rid of it. We just want to address some of the due process issues that have been raised, not just amongst practitioners, but actually in federal courts. We know of at least 3 lawsuits that have been brought in federal courts in other states regarding how Child Protective Services have used these types of agreements. And those courts have found that one issue is the PCSP agreements, or what we call safety plans in other jurisdictions, are inherently coercive in the way that they're presented because they present this false choice. Either agree to an open-ended supervision with us or face the threat of having your child formally removed into the foster care system. Another piece that this bill addresses that has come up in these lawsuits is that time limit. There was actually a North Carolina case where the daughter who was removed under one of these agreements, I believe, won $3.1 million, and her father won $1.5 million in damages. This was a North Carolina case. And one of the reasons why the court ruled in favor of this family was because there was no evidence that this child was in danger, and they found evidence that the CPS system was using the arrangements to manage what they called stuck cases, manage cases where they didn't have enough evidence to go to a removal, but they could keep these families separated and under supervision for an untold amount of time. I think this family was separated for well over a year under one of these arrangements when there was, in fact, no danger that a court could find. So the changes within this section of the bill are really designed to incorporate what we've learned, but also give the department an important tool and what I like to call a release valve for removal that is still within proper guardrails of due process protections and allowing families to consult with legal counsel before agreeing to the arrangement. And I'd be happy to answer any questions you might have on that.
Any questions of Representative Wolf?
Thank you, Chairman. And, I feel like we're on the same side, but we're just looking at this from 2 different perspectives. I kind of see what you guys where you're going with this. So, your concern is that the parent-child safety plans are never ending, right?
Exactly.
And my concern is that if the more a family touches the court system, the closer they are and more likely they are to head towards termination. And so, like, my concern is, like, I want fewer families headed towards termination.
Agreed.
Right? And my concern is that if this tool over here that lets us deal with a lot of stuff that actually, a lot of those cases that are in FBSS are eligible for removal because, like the bulk of the cases in my experience are drug cases where mom or dad has already tested positive for drugs. It's already in our code that is the basis for removal, that if someone is currently using hard drugs, it's already grounds for removal, and they could already remove them. And my experience has been that, especially with drugs, that you know, especially some people, they have trouble. They go get a little treatment. They do some of the stuff that they're told, but then they have a relapse,
Right.
and then they start back up. And we have a come to Jesus meeting, and he's like, hey, can you get back on the train? And they'll go again, and then they'll have another relapse, maybe like 6 months down the line, and whatever it is. My concern is, like, those are the cases I wanted kept out of termination proceedings.
Absolutely.
Right? Because based on the set of facts, there are already grounds for termination. Like, you have a parent who is actively using drugs, there's grounds for removal, there's grounds for termination, but the kids are okay. Right? But if the safety plan says, hey, we'd like for auntie to stay with y'all, right? And it could be that. It may not be removal. It may be like, we want you to have another responsible adult live in your home and help look after the kids to make sure that everything's okay.
Mm-hmm.
And they're perfectly fine with that. And that goes on for a while, right? And potentially a lot more than 90 days.
Right.
And from me, as someone who represents the parents who will get their kids terminated, taken away permanently, like, I would rather them stay in that sort of, if you want to say, the gray area,
Right.
for as long
the
as
child
possible,
is still in the home.
because the child is still in the home. They're in absolutely no danger of losing them. But the moment they touch a court system, the moment they touch a judge, it goes in front of the judge, and the judge now has expectations of, you better stop doing this, or I'm going to take the next steps. That's what I'm scared of.
Right, and I'm looking back at the language on the bill, and I don't want to testify for something that's not, but I know we had a conversation within the work group that really kind of related to, is this a time limit on the services, or is it a time limit on the amount of time the children can be placed outside of the home? Let me go back and double check the language, and I can follow up with you
Sure.
after that, because I don't want to say that your situation would not be affected if I'm not sure about it. But I do recall that we had this conversation about really limiting the time that the child is outside the home as opposed to other types of services.
I'm happy to talk about it.
Yeah.
Again, I don't think we're on the opposite sides of this.
No, not at all.
Sure
And I completely
we don't-
share your concerns as well about not wanting to incentivize the department to just rush to removal.
Yeah.
Any further questions of Mr. Brown, members? Not hearing any, Mr. Brown. Thank you for being here. Chair calls Julia Hatcher.
Hi, Chair Dutton, committee members. My name's Julia Hatcher. I'm an attorney in Galveston. I'm also president of the Texas Association of Family Defense Attorneys and helped work on this bill, and so we are in support of it. And just real quick, to answer your question, Representative Wu, I think you're talking about a safety plan where a supervisor comes into the home to help watch the child while okay. So the safety plan and the parental child safety placement are two different, they're supposed to be, two different forms. And so this bill specifically addresses the parental child safety placement and specifically defines that as any agreement where the child is placed outside of the home.
Yeah.
So it would not affect those safety plans. So I just wanted to touch that real quick.
Yeah, Representative Wu, I think, has a question.
Sure.
So no, but even still, like, a lot of the situations I've personally come across is the child is placed with grandma, the child is placed with auntie, or whatever, or mom and dad are separated, and dad gets like primary conservatorship, a primary residence, right? And mom and the kids only come over every so often, whatever it is, right?
Sure.
And again, from my perspective of representing parents who are going to lose their kids, right? Because they started down this pathway, because they started the petition, and once it starts, there's no way to really finish it unless everyone's really on the dot. Is that I wouldn't say like my clients would have rather their kids stayed with grandma and been able to keep it that way than to start this process of you have a year to get all your crap done or your kids are gone forever.
Well, I understand that. In between the PCSP and the termination, we have the court order services cases, which was amended in 567, as you know. And I'll just give you a story. I had a client come in last week who had been in a parental child safety placement for 8 months. 8 months. She did every service that CPS wanted her to do, and then they wanted her to keep doing more services. And I said, that's a voluntary agreement. You can go get your child. Well, CPS had told the caregiver, if you let mom come get her child, we're going to come take your kids, which is completely illegal. So, you know, those are the kind of situations we're trying to address, where parents, they haven't been given their rights. They don't know that they have the right not to sign a parental child safety placement. They don't know that they have the right to talk to an attorney before they sign one. Once they get into one, they don't know how to get out of them. So that's a big part of the problem that we're trying to fix with this. And then regarding the court-ordered services cases, so they're in this parental child safety placement. If they don't do what they're supposed to do, theoretically, then it can move to a court-ordered services case, which is the step before termination. Okay. And in the court-ordered services cases, when we amended that, when y'all amended that in 567, believe the intent was to keep the children in the home while the parents are doing the services, right? Okay. But what's been happening all across the state is that courts have been using a loophole to remove the kids and force them to stay in a parental child safety placement while the parents are doing their services. And so this bill addresses that too, so that that will no longer happen. And so this is a really, really good bill. As far as the time limit on the PCSP, there is a provision in the bill that says that a parent can agree to extend it past 90 days, as long as a parent agrees and the parent's attorney, if the parent has an attorney, agrees. They can extend it. So if they go into a court-ordered services case and the parent, because every parent gets an attorney in those, right? Every parent and every child, they're supposed to. If they're indigent. If
Yeah,
they're not indigent, hopefully they could go hire one, but they should have one. Anyway, they can always agree to extend that PCSP while they're in the court-ordered services case if they're looking at a possible removal action. So I think all of this was discussed. There's so many of us that worked on it over months, and I think all of these are good questions. Hopefully we've addressed most of them. I would say it's almost a perfect bill. And so for that, we would ask you please to pass this out of committee. Are there any other questions?
Any further questions, members of this witness? Not hearing any. Thank you. Thank you for your testimony. Thank you for being here. Chair calls Megan Corser, who was the last witness, I think, on this bill. Who wants to hear from her?
Good afternoon, Mr. Chairman and members. My name is Megan Corser. I'm the Chief Policy Analyst at the Family Freedom Project, and I'm here testifying in support of HB 730. I'd like to kind of quickly speak to how the bill came together. There have been a number of issues involved in the CPS system that have come to light over the last couple of years that a group of us got together to work on over the interim. There were 10 groups that spent months working on some of these big issues. These are very complicated but important issues that we have worked really, really hard to try and put together good solutions for. And there are two pieces of the bill that I'd like to talk about in particular. The first is the parental child safety placement piece. Representative Wu, the concerns that you've expressed are concerns that we discussed ad nauseum during the work group meetings. And the conclusions that we came to were that the current language in the bill would address those concerns for a couple of reasons. The first is that the statutory definition of a parental child safety placement limits the scope to purely out-of-home placements. So if there's a third-party caregiver who's residing in the home, that's beyond the scope of a parental child safety placement. If the parent is receiving services, that's beyond the scope of a parent-child safety placement. So our typical FBS services are not within the scope of the parental child safety placement definition in statute, and the PCSP section is what we're talking about specifically in the bill. Secondly, the statutory definition of a PCSP limits its application to a written agreement between the parent and the department. So if the parent voluntarily chooses to place their child outside their home on their own. So parent says, I'm going to send my kids to grandma's house voluntarily outside of a written agreement with the department. That's still allowed. And so there are safety valves within the current statute that would allow a child to be placed outside the home beyond the scope of a PCSP because it's the parent's voluntary decision. And we don't want to impact those at all. And we think that the language in the bill strikes a good balance there by providing time limits on these written agreements for out-of-home placements with the department, but still allows the parent to do so voluntarily, still allows the parent to receive FBSS services. So maybe in a drug case that is their drug treatment or that's their alcohol abuse treatment. And so the parents can still receive these services, but we're purely limiting the scope of these out-of-home mandatory placements because there is a lot of coercion and lack of due process that we see in the current system where parents are often threatened with formal removal of their children if they fail to sign a PCSP. And so we want to include due process protections there, but account for a lot of the concerns that Representative Wu brought up. And so for that reason, I believe that the language in the bill does address those concerns, but would be happy to discuss that with you guys after the committee hearing if there are more questions. The second piece of the bill that I wanted to talk about was the Orders in Aid of Investigation statute. An order in aid of investigation is the CPS mirror to a search warrant in a criminal case. And that's a tool that DFPS can petition a court for if they want to go into a child's home to interview the child, to inspect the home, to meet with parents, things like that. They're investigative aids. And what the bill does is it raises the standard to obtain one of those orders in aid of investigation from good cause to preponderance of evidence. Good cause is not defined in statute, and the appellate courts have never really clearly defined it. The closest that any of the courts in Texas have gotten is copying and pasting the Black's Law definition of good cause, which is a legally sufficient reason. The court failed to explain what a legally sufficient reason would be, and so there's a lot of ambiguity around the circumstances in which a court could grant an order in aid of investigation from a legal perspective. There's very, very limited case law on that subject. The Fifth Circuit said in dicta that it thinks the good cause standard in the order in aid of investigation statute is equivalent to probable cause. That's really the closest that we've gotten. And so there's just a lot of ambiguity. And so the kind of result of that is that there's only been one appellate case in Texas in which the appellate court has said that CPS did not have good cause to obtain this order in aid of investigation, and that case was overturned on appeal. But that is one case in all of Texas jurisprudence history. And so there's really just a lot of lack of clarity on this issue, and preponderance, as we know, is the default standard in the Family Code under Chapter 105, Section 105005 of the Family Code. Preponderance is supposed to be the default standard of proof in all family law cases, and so the bill would just raise that standard in the order in aid of investigation statute from good cause to a preponderance of evidence, which again is the default standard. I'd be happy to answer any questions about the language of the bill, but I think that is the scope of the comments that I wanted to make sure I shared.
All right. Show Vice Chair Lujan present. So you believe that the going from good cause to preponderance of evidence is raising the bar?
Correct. So, like I said, there's a very limited amount of case law on the issue.
Yeah, right.
Like I said, we have one definition, which is a legally sufficient reason. That the courts didn't really explain what that means. Fifth Circuit said in dicta that they think it means probable cause, maybe. At any rate, I think the agreement was that the default standard preponderance was reasonable, and we wanted to make sure that applied to the order in aid of investigation statute.
And it clears it up more than raising the standard.
Correct.
Would that be fair? Okay. All right. I think Representative Wu has a question.
Thank you. No, I'm glad you brought this section up because I had questions. I mean, like, I know the standard for a search warrant is probable cause.
Correct.
And this preponderance of evidence would actually be a higher standard than just probable cause.
Correct.
So it would be harder to get information from a home, school, or any or whatever other setting for a child abuse case than it would be for a criminal search warrant?
So let me address that in particular. So the Fifth Circuit's dicta said that because the standard of proof required in criminal cases is probable cause, and that an order in aid of investigation is kind of the CPS analogy to a search warrant, that probable cause is probably what the current standard means. And so that kind of was the Fifth Circuit's reasoning in that dicta there.
Wait. So Fifth Circuit says we think the current standard of good cause is the same thing as probable cause on the criminal side.
Correct.
And,
there was one Fifth Circuit case about 10 years ago in dicta.
But this bill then makes the standard now much higher into preponderance of the evidence. That's way above what a probable cause, even for a criminal search warrant, would require.
Correct. And probable cause being or preponderance of the evidence being the default standard in the family code. I think kind of the agreement was that that's a reasonable standard.
But the preponderance on those settings are for other things, not for just like, hey, can we do some investigation? Right? Those are for like decisions on where the child should be placed, where what kind of services, whether or not parents finish their services or whatever, right? Not whether or not that they can get access to information about whether or not there was abuse.
Right. So the orders in aid investigation are only used in specific types of investigations. So basically, CPS needs access to the home,
right,
or they want to interview the child. They want to go get a forensic interview of the child, whatever the case may be. There are a couple of release valves. Number one, if there's an accompanying criminal case, all of that information can be obtained on the criminal side. Through the normal probable cause standard for search warrants. The second was that the standard for removal of a child is probable cause. And so the bill doesn't impact the standard for removal, only these pre-removal investigation orders. And we wanted to make sure that there was proper due process on the investigation side before we get to the question.
I mean, isn't the standard for removal actually lower than preponderance of the evidence?
The standard for removal is sufficient evidence.
So it would be easier.
Person of reasonable prudence and caution.
I mean, this is what I'm cautious about, in that we don't create situations that have the opposite effect. That, like, so basically, it's easier for CPS to actually remove the child than it is for them to get essentially a search warrant.
I would disagree. The standard of proof might be higher, but the substantive grounds that they have to prove for removal are a lot higher than they are for an order native investigation. So, for example, the grounds for removal require an immediate danger to the child. One of those grounds is immediate sexual abuse danger, danger of trafficking. The substantive grounds for removal are a lot more stringent than the grounds for an order native investigation.
Right. I'm saying, like, if they're trying to get access to medical records, they're trying to get access to the home, trying to get access to whatever else, and just as a part of the investigation, and whether what they discover can either say, oh, well, never mind, that this contradicts what we found earlier. If they found something earlier that says, oh, I think we have enough grounds for removal, they're gonna say, well, screw it, let's not bother with the warrant or whatever and looking for this extra information. Let's just go ahead and do the removal. If they have enough, I'm sorry.
So maybe
I don't want to bog us down with. We can talk about this afterwards.
Sure. Would you prefer to talk about it afterwards or now?
No.
Afterwards.
Later. Afterwards.
Okay, great.
Afterwards is always better. Any further questions of this witness, members? Maybe afterwards. And the chair calls Marta Talbot, who is from DFPS, testifying neutrally on the bill.
Hi, Marta Talbot, Department of Family Protective Services. I'm the Acting Associate Commissioner on the bill.
Thank you. I think Representative Wu has a question.
I have questions. Sorry, give me 1 second. I'm looking at. I mean, I like the provisions in the bill about just providing some general warnings and stuff, but my question on some of this stuff is, like on page 4 of it of the sub, it says you have a right to not speak with any agent of the department without legal counsel present, or to have a court-appointed attorney if the person is indigent or a person is parent. The person is a parent of the child, and the department seeks a court order. Blah blah. Is there a process in place right now for investigations to provide appointed attorneys?
No, we do not provide court-appointed attorneys unless we go to court for removal and/or court services, and at that time, they could be appointed one, if indigent.
Yeah, but it's only if it's
Only
a
if there's
participation in
court.
services or if it's or if it's a termination case, right?
Correct, only court
So,
involvement.
my concern is, you have something like 400 investigations a year. What's the number of investigations right now?
For a fiscal year, we're right around that 166,000.
Okay. My concern is that if we're telling people they have a right to an attorney, the court-appointed attorney, I just want to make sure we know who's paying for it. Like, is there money in your budget to provide an attorney if somebody asks for one?
No.
Okay. So I guess it would fall onto the courts, the counties to pay to provide an attorney.
Yes, or we would need to relook at our fiscal note around that, because the way I understood it was if we go to court. So if I have to file a court order of services, or if we have to file, that's how I understood it, was that at that point is when they would get some kind of attorney. But I do think you're correct. If I told a parent you have the right to an attorney, or you have the right to counsel or consult with counsel, I think at that point, sometimes there are questions for us of like, how do I get one then? Right? As a parent, that's sometimes their questions of coming back is just, well, how do I get one? And no, I don't want you to see the child until I have an attorney. And so at that point, we have to make determinations on what to do with that case if we have not been able to assess for abuse or neglect to a child.
Just moving on a little bit. I don't know if you have. Do you have the substitute? Do you have a copy of it?
Yes.
Okay. On Section 3, on the ex parte hearings, and those are usually done for, like, ex parte hearings are like emergency hearings, correct?
Yes, typically they are, what we do typically is we send in our affidavit for review by the county attorney, and then the judge reads it and signs off. Typically, there's not an actual hearing for the ex parte.
And whether or not those are recorded, those are actually, they are on the record, aren't they? Or are they not?
No, not that I'm aware of, that they are not on the record, because that's usually just the judge reviewing and signing the affidavit.
Yeah. And I know on Section 3 of the bill, I think it's important to keep records of, especially probably of the ex parte hearing, but that's something that's handled by the courts, right?
Yes.
So the county would have to pay for that.
Yes.
Okay. And so if there's a requirement of keeping audio, video, or a court reporter transcription, would that fall on y'all or would that fall on the counties?
Counties.
Okay. Okay. Thank you.
All right. Any further questions of this witness, members? Not hearing any. All right. Thank you for being here.
Okay, may I add something just real quickly, just in reference, because this was mentioned, and I want to make sure that it is known that we do have the fiscal note, and Chair Frank is absolutely correct. There was some different information in there, or kind of inconsistent information, and I did check on this before I was up here today, and we should not, basically, we are uncertain of some of the cost, right? Like, we cannot say that there will be more removals. We cannot say there will be more motion to participate. So we will get that corrected, that I think there was some inconsistent, that we're just basically uncertain if this will increase removals or not. So we'll have that correction.
Okay. All right. Thank
Okay.
you.
Thank you.
Thank you. Any further questions of this witness, members? Chair hears none. Chair recognizes the Honorable Chairman Frank to close.
Thank you. Thank you, members. I think I told you the truth at the start when I said it wasn't a simple bill, right? So I really appreciate it. Don't have a tremendous amount to say other than that I think the work that we've done to decrease the number of removals with the with the clarification of neglect has been very helpful. I think there is still a tremendous amount of work to do at the agency in terms of professionalism and consistency. Professionalism sounds a little harsh, but consistency with the way we do investigations. You heard, hey, most of these things happen ex parte, the parent's not around, they don't know what their rights are. Judge rubber stamps it, and they're a month, 2 months into the process before they know what's going on. It's not, in my opinion, that's not okay. We can do better. Whether there's a cost to the counties, these same counties, while I'm sure they would absorb some cost, have also had a 30% decrease in the number of cases in the last 2 years. Don't think anybody got a thank you letter for those. This is simply better for the parents, and I don't think it will change the removals. I think letting parents know what is going on is a good thing. Allowing them to have representation earlier is a good thing, and I think it will mean less kids get pulled into and honestly, the safety placements, which it is very clear in the words of the bill, this is only removals out. This is not inside the home. This is only outside the home. There's only ones. There should be less than 90 days. Honestly, at some point, I'd be fine getting rid of that if we have another place for them, which we don't right now. We don't have that system. I did think while we were up there that maybe we need to have some type of judge oversight of all parent-child safety placements, that may be something that we could consider. But bottom line, I really would appreciate your favorable consideration. While I think it's a great bill, it's certainly not a perfect bill. Anybody that wants to discuss, certainly Representative Wu, we've had a good time working on this in the past, and will again. Would happy to make any necessary changes. And with that, I'd be happy to answer any questions. If you don't have questions, then I'm happier to close.
Yes.
I just want to say that I appreciate your leadership in this, and I know I have some individual small.
And I really think I was looking back at that, the preponderance of evidence, because a lot of this was done. If you look at who participated, this was not a stacked. There was honestly people with both sides of the political spectrum that were engaged, but that doesn't mean it was perfect, right? You can still have groupthink in any type of meeting, and I think that preponderance of evidence may be a little bit.
That's why I want to say
something. Absolutely, that's something that we can work on.
Yeah.
I do think it is just tremendously important that we continue. I consider a removal a police action. Okay. And we need to have those protections. Not everybody thinks we're protecting the parents. We're protecting the kids from getting removed when they shouldn't have gotten removed. Okay, yep. It's not parental rights. It's yes. I believe strongly in parental rights, but the kid has rights too, and not to get jerked around into a system that's going to take an average of 21 months to get them out of. So anyway, with that, thank you.
Representative Cook.
I was just concerned about you being told that this was a perfect bill. I know you're arguing against that now, but
well, it's really nearly perfect. Yeah, really nearly perfect.
And I'm probably more bothered by the statement that the Health and Human Services is the most powerful agency, and knowing that you're the chairman of that committee. Really.
Well, I think they were saying the Department of Family and Protective Services.
More specifically,
was the yeah. We're working on it. Yeah. We're working on it, and they do a great job. They get beat up. There is. Honestly, when you deal with these issues, there is no perfect, because you have this tension, and if you go too far this way, then you're dropping the ball over here. And so we're not trying to fix something. We're trying to improve something. I always say, we're just trying to make it better. But I think part of that is more consistent, more professional, more informed, which is what you're talking about in this bill, I believe.
Yeah, I did want to join Representative Wu in saying thank you for all the time that you and your staff have spent. I know that this has been a long journey, and so we are certainly appreciative.
I think the different folks that have been. I'm not a lawyer. It always scares the heck out of me anytime I touch law. So it is why, honestly, we've got a bunch of lawyers together and a bunch of groups together to try to work through that. And me and my staff shepherded that process, and I think we've arrived at probably 95% of the solution, but there's probably some other tweaks that we can do, but I would appreciate y'all helping move it along with any comments, and then eventually your quick favorable consideration.
Well, thank you.
All right.
I want to join. Thank you too. One of the things that I've come to realize in the legislature here is we design things so that solutions so they're one size fits all, and then they end up fitting nobody.
Very true.
But that's a problem we don't have just in this committee, but in just about every committee I've been on. It's the chair's intent to withdraw the substitute to House Bill 730 without objection. Chair is none. The substitute's withdrawn. and it's the chair's intent to leave House Bill 730 as a matter of pending business before the full committee. Thank you. Chair lays out House Bill 698 and recognizes the Honorable Chairwoman Criado.
Thank you, Chairman. Vice Chair Lujan, members, thank y'all for the opportunity to lay out this bill. This is legislation that came from work that this committee did during the interim. It was, the speaker had an interim charge requesting that the committee examine the obstacles to the reporting of domestic violence and to look at any new technologies that could facilitate the reporting without putting victims at risk of further harm. And during the interim committee hearings, we heard testimony from advocates from family violence centers who talked to us about how virtual hearings, specifically in protective order hearings, made a big difference in numerous ways. We have some advocates who are here, the Texas Council on Family Violence and others who will be testifying about why this bill is necessary. I'll share with y'all a data point. Back in, well, we saw a huge rise in domestic violence reports during the pandemic, but even since then, in 2021, the Department of Public Safety said that law enforcement officers in Texas responded to 232,840 incidents of family violence. That was up from over 213,000 in 2020. And as y'all know, protective orders are those tools that a court has or a family has in those extreme situations where you need a protective order in order to protect the individual from their perpetrator. So during the interim, we drafted and prepared this legislation, which to address the ideas that came out of the interim committee report. And one of the reasons that this is essential is that when courts were essentially needing to turn to the virtual option, they found that specifically in protective order hearings, respondents were more likely to appear, that there were situations previously where an applicant for a protective order, which is usually the person, the survivor of domestic violence, they were being followed by the perpetrator after the court hearing. They would have to ask the bailiff to walk them to the parking lot. There were situations where air tags were being put to track down the survivor of family violence. And so what this tool did essentially made people more likely from both sides able to be willing to come to the courthouse. And so we've got some amazing advocates. I do want to highlight there is a fiscal note on it with respect to the Zoom licenses. We have reached out, and I'm not sure if OCA, the Office of Court Administration, is here, because from our understanding, a lot of the courts already have these Zoom licenses. We think that the Zoom licenses may be in the budget already, so we're just trying to check to make sure, and we'll follow back up with the committee on that to make sure that there's not an additional cost if it's already being covered by the Zoom licenses. So we would love your support for this bill, and I'm happy to answer any questions, but this is really a safety issue for applicants, survivors of domestic violence, and a tool that just makes sense that will help increase the number of people attending and hopefully get folks in safe situations. So with that, I'm happy to answer questions or reserve my...
Any questions of Chairwoman Criado, members? Not hearing any, thank you. We'll reserve the right to close for you. My computer shut down. The chair calls Ariana Chalazur. That probably didn't say that right. Chalazur. Yeah, okay, that's what I thought. Okay.
Good afternoon, representatives. My name is Ariana Chalazur, and I'm a law student at SMU Dedman School of Law and also an associate member of the Texas State Bar as part of SMU's Gender Violence Clinic. I'm testifying in favor of the passage of House Bill 698, which would allow survivors of domestic violence seeking protective orders the option of participating in their protective order hearing virtually. Many courts in Texas successfully conducted virtual protective order hearings during COVID. To learn more about the experiences of people that had these hearings over COVID, SMU's Gender Violence Clinic conducted 2 surveys, one for prosecutors, attorneys, and judicial officers, and the second for survivors and advocates. Numerous benefits of virtual protective order hearings were identified in these surveys, but today I would like to highlight 3 for you. 1, the overwhelming feeling of safety. Attorneys noted that applicants were more likely to seek the court's protection when the risk of being assaulted or intimidated in or near the court while attending their protective order hearing was removed. 2, attorneys mentioned that they were able to represent more survivors and dedicate more time to each individual survivor when they didn't have to spend that time commuting to court. And 3, removal of barriers. When survivors escape their abusers, they're forced to uproot their entire lives. In the depths of their trauma, they hurriedly find a shelter, a new job, and care and schooling for their children. Having a virtual option for protective order hearings removes one of the many barriers victims escaping life or death situations face. Mr. Chairman, since you're an alumnus of Thurgood Marshall School of Law, I would like to read a quote from Justice Marshall. Mere access to the courthouse doors does not itself assure proper functioning of the adversary process. Survivors of domestic abuse may technically have access to the courthouse doors, but the justice system does not properly function, justly function, when survivors are too afraid to seek these protective orders because they fear the physical retaliation from their abusers. Survivors, after everything they've been through, should at least have the right to a fair, just, and safe hearing to get an order that could potentially save their lives, which is why I urge you to pass House Bill 698.
Well, thank you. Thank you for being here. Ms. Schallinger, right?
Yes.
Well, thank you. You're a second-year student?
Yes, Mr. Chairman.
Second year? Okay. Well, that's great. I commend you.
Thank you.
That's a great presentation. So let me see if there are any questions, though.
Okay.
Any questions for those witness members? Not hearing any. Thank you for being here.
Thank you, Representatives.
Yeah. Great presentation. Chair calls Aaron Setliff.
Mr. Chairman, I apologize to interrupt you. I have some handouts
Yeah.
when I approach.
Oh, sure.
Thank you so much.
All right. Chair calls Aaron Setliff.
Good afternoon, sir.
That's a tough act to follow.
I know. I'll do my very best. I did give out some handouts as well at the very beginning. It's a longer piece of paper, actually. It looks like this.
Well,
So,
let's
I'm
identify
Aaron-
yourself
Yes,
first,
sir.
okay?
Yes, sir. I'm Aaron Setliff. I'm an assistant county attorney in El Paso. I'm representing Joanne Bernal, the elected county attorney. I appreciate the time to be able to address you, Chair, and I appreciate Chair Moody showing up in support, I'm sure. And then, of course, Chair Criado for filing the bill. So I just want to explain from El Paso County's perspective why remote witness testimony has been such an amazing resource for us. You know, we do an online application process. I'm the trial team chief of the protective order unit at our office. We do an online application process. Last year, in fiscal year 2022, we had 2,578 applications online. During that period of 2022, we experienced a 60% rise when it comes to those applications. So in reference to remote witness testimony, I can specifically show you or point you to 2 key metrics. As this document recounts, we have seen, when comparing in 2019, when we did in-person exclusively, and 2022, we saw a 54% decrease in non-suits by applicants. That's lawyerese to say that applicants go forward with protective orders after we filed them in 54% more of the occasions. That's where it really matters, when you're actually applying and you move forward, despite all the obstacles that might be in front of you. The other metric I want to offer you is that we've seen an increase in contested cases. So that's more work for my attorneys, I understand, but compare it to 2019 when we had 25 contested cases. In both 2021 and 2022, we had 77 and 55 contested cases. What does that mean? It means that respondents are actually participating in the civil justice process, and they're participating in a contested matter. More due process for respondents. Judges support the use of remote witness testimony for precisely both of those reasons: more participation by applicants and more participation by respondents. I want to tell you a quick story about our client, Arlene Macias from El Paso. She would have been here this week, but she had a car accident on Friday. She's probably watching. She wanted me to tell you a little bit about her story. She's a woman in her 40s. She had a daughter that was 10 years old. She had the father of her child one time came to her house, destroyed her bathroom, threatened her, and kept her from calling 911. On another occasion, he got angry when another person messaged her and pushed her around, pulled her hair, pushed her daughter into a wall, and said, "See, this is what mom gets for talking to other guys." On another, she broke up with him, obviously, after that. And after that, for a year, he made incessant calls and texts saying things like, "If I see you, you're going to see what happens. I'm going to break your face in." Arlene is a part of the 54% of applicants that continued forward even though she was afraid. I asked her, "Hey, what do you want me to tell the members of the committee this afternoon?" She said that she would not have gone forward if she had to face him in person. So I ask your favorable consideration for HB 698 and appreciate your time.
All right, thank you. Let's see if there are any questions. What's the downside to this, or if there's one?
Judge, I've been looking for one. I mean, we handle exclusively remote witness testimony. And I see it on both sides. Both the respondent and the applicant are more likely to participate rather than getting default orders where the respondent just doesn't even show up. The bill does allow for good cause shown. I started to try and think of what I might show for good cause on the respondent side for not doing a remote witness situation. And I started thinking maybe in certain circumstances, jurisdiction may be an issue, and that may be good cause to have them actually show at the courthouse. But Chairman, I've thought through this.
I guess the availability of people to have access to the internet, and certainly high-speed internet, or the ability to traverse all the things that you need to do to get online,
I agree.
for example.
Yeah, I agree, and that might be good cause for the respondent, for instance, to say, "Hey, I can't make it to, or I can't do it remotely, so I would like to go to the courthouse." And our practice is, for sure, anyone that wants to go to the courthouse can go there.
So you wouldn't just restrict it so you'd have to do a video.
Yes, sir. The bill as written is the applicant would apply, and the court shall grant unless good cause is shown. So if the applicant wanted to go downtown, we certainly would accommodate that. And we have some folks that come downtown to apply.
And if the respondent wanted to do that?
Yes, sir.
Say the applicant made the request in writing, and the judge granted that, that would force the respondent to also have to do that, right?
Under the way that the bill is written and the way I'm reading it, Chairman, and I could be corrected, is so a witness, applicant or witness is the language, and they shall be allowed to testify remotely unless there's good cause shown. And so in that instance, I think a respondent who wants the applicant to show up would have to show good cause to make the applicant or witness actually show up. As far as the respondent is concerned, the respondent could choose to do it remotely or not.
Okay, that's what I meant.
Yes, sir.
The respondent could still have the option to do it remotely or show up in court.
That's my reading of the bill. We have experts that wrote the bill here, but that is my direct understanding. So.
And I was just wondering when it said, and the applicant or witness, whether or not that was inclusive of the respondent.
Well, I'll tell you, Chair, a lot of times I will call the respondent. So that makes them a witness under the bill.
Well, that's kind of what I thought too. Okay, all right.
Thanks for those questions.
Any further questions, members? All right, thank you.
Thank you, sir.
The chair calls Catherine Miracle.
Good afternoon, Chairman.
Good afternoon.
Good afternoon, members of the committee. My name is Catherine Miracle. I am here representing Dallas County District Attorney John Crusoe. I am an assistant district attorney in Dallas County. I have been a prosecutor in protective order court for the past 7 years, and I'm here to testify in support of House Bill 698. The experiences that Dallas County has had are very similar to the experiences that Aaron just talked about. The virtual protective order platform that we've been using for the past 3 years has benefited all of the parties involved in our protective order hearings. It has been astonishing how positive it has been for our court, for applicants, and for respondents to be able to have the opportunity to appear virtually in our hearings. Let me first address the positive implications that virtual orders or virtual protective order hearings have had for applicants. First and foremost, safety. Applicants feel much safer appearing before their abusers when they are online. They don't have to appear in front of them in court. They don't have to sit in a courtroom with them. They don't have to face the fear of being followed into or out of the building. Everyone arrives at the same time for their court hearings. Oftentimes they run into their abusers in the parking garage. We don't have protection for them out there. Sometimes we can find a bailiff to escort someone in or out of the building, but when we're dealing with a docket with 15 cases per docket setting, we don't have 15 bailiffs to escort people to their cars. We just can't do it. Oftentimes, respondents will follow the applicants out of the building, out of the courtroom, into the parking garage, and follow them in their cars to their safe locations. We've had many applicants who have had to contact us to be transferred out of their shelters because their abusers have followed them to their shelters after their protective order hearings. Now that we are online, now that our hearings are virtual, we just don't have that problem anymore, and it's been such a blessing for the applicants. Applicants also are benefiting personally from the protective order hearings being virtual. They no longer have to secure childcare. They no longer have to take time off work to appear before our judges and before the protective order court. That was often very cost prohibitive to our applicants. These are people who are just getting out of relationships where sometimes they have not had the financial freedom to work. They've not been permitted to work. They've not been permitted to put their children in childcare, and all of those things are brand new to them. They have to do that all for the first time. Having to come to court repeatedly, different court settings, if a respondent asks for a reset of a case, if an attorney asks for a reset of the case, coming over and over again, taking multiple days off work was really cost prohibitive to our applicants, and that no longer occurs anymore. Scheduling childcare, expenses of paying for parking at the courthouse, all of those things have been avoided by having a virtual platform for our applicants. As Aaron was talking about earlier, many more of our applicants are showing up for court. They're not as scared. They're still scared, and oftentimes we suggest to them, if you cannot face your abuser, put a sticky note up on your computer screen so that you don't have to look at them. And that gives them a lot of comfort to not have to be face-to-face with their abuser, but still be able to testify. Let me give you an example of a case I'm working with right now. My applicant appeared on Monday virtually. She is 16 years old, and she applied with her parents' assistance. She is a member of AA, and her parents are being very supportive of her, and there is another member of Alcoholics Anonymous who has been stalking her. She is 16, he is 38 years old. They have never had a physical relationship, ever. They have never had any personal communication with each other. This is a man who has some very serious problems. He found her email, he found her social media, and the messages that he is sending to the 16-year-old child they're horrifying. They are horrifying sexually, they are horrifying in a violent manner, and this 16-year-old girl having to appear in a courtroom with this man when she's never had a relationship in any way with him would be so traumatizing for her and for her parents. They all thanked me the other day, on Monday. The case was reset, but they all thanked me for having this opportunity to appear virtually. This man has done this to 14 other women. She's number 15 that he's done this to. So the fact that this child does not have to appear in person is a huge benefit for our victims, and we've heard this over and over again. We had a social worker appear in our court. She had often appeared in support of other victims. Now she appeared as a victim. She had applied for her own protective order. She said when she came to court with other victims, it was very stressful for her to appear just in support of someone else. But coming as a victim herself, she said it was a feeling she had never experienced before. She said that having to build up the courage to come into court over and over again is asking a lot of a victim who's already going through so much to get themselves out of that violent situation. She said the virtual experience gave her the courage to continue fighting, setting after setting, and finally get her protective order. This virtual platform has been such a benefit not only to our applicants, but to respondents as well. They also don't have to take time off work. They don't have to pay the expenses of coming to court. They have an opportunity to participate in the process much more. We're seeing respondents show up in our court. Many fewer default judgments are being entered. We don't like default judgments because we want the respondents to be in court, to have the judge admonish them about their responsibilities under the protective order, and to admonish them of any criminal consequences that could occur if they violate the protective order. It's always better for us, for our victims, and for any further criminal charges that could be filed for violations if a respondent shows up in court and hears from the judge exactly what is expected of them. All the parties have benefited from these virtual protective order platforms. Safety, convenience, comfort, efficiency, all of those things have increased over the past 3 years since we've been on this virtual platform. And Dallas County has really been able to provide a superior level of care to our victims and to everyone involved in the process because of these virtual hearings.
Thank you, Ms. Merrill. Thank you for your testimony. Members, any questions? No?
Thank you very much.
Thank you. At this time, the chair will call up Krista Del Gallo. If you come up here and state your name and the organization you'll be testifying at. Sure.
Good afternoon, Krista Del Gallo. I'm the Legislative Director with the Texas Council on Family Violence, and I am thrilled to be here to support House Bill 698. Much gratitude to Chairwoman Victoria Navicrado for filing this bill and for you and your staff's ongoing commitment to survivors. We really, really appreciate it. I also really appreciate that pizza I got to eat in your office today. It's the only thing I've had so far, so I'm excited. So you all are lucky because of that. And I'm also very grateful to this committee. You all invited the Texas Council on Family Violence to provide organizational testimony earlier on in the session. And so that wins you from being spared from my TCFV spiel in this testimony. So I'll just launch right into why this is so important to TCFV. You've heard some fabulous information about the benefits from the witnesses already. TCFV, this legislative session, has only 4 substantive bills that we are calling our legislative agenda items. That's because every session we prioritize funding for family violence centers, and then we go through an extremely, usually about a 1.5-year process with our public policy committee to determine what are those very discrete items that we must push in a legislative session that we feel that we can't wait another 2 years to attempt to accomplish for survivors and the programs that serve them in Texas. And this codification of the option for applicants of protective orders to be able to request and be granted a virtual hearing made it to that list. This came to us from Dallas County, from advocates, well before our public policy committee even started talking and having deliberations about our agenda making. And the advocates were just like, how do we make this permanent? And it was also very refreshing to hear from them because they were in a county where their prosecutors and their courts were continuing to hold virtual hearings. And they not only feared that it might not go on forever, that was an option, but they could look around to survivors in other jurisdictions where this was not an option. And so we want to see a Texas that affords this kind of highly beneficial option to survivor safety and this highly beneficial option for access to such an important tool that is protective orders to be afforded to folks across the state, no matter where you live. And there is an opportunity within the bill, as you can see, for the court to deny the request for good cause. And we have 2 judges on our public policy committee. One is out of El Paso, one is out of Beaumont, Judge Randy Shelton. And he was unable to be here today, but he shared with us that he really likes the shall language. He actually thinks it's imperative. And he said, we judges tend to have a default setting, which is live hearings. And being a victim can be so crippling, and victims need this option. Taking time from work, finding babysitters, and feeling safe are just a few reasons why victims deserve this right. Judges will like the flexibility to deny the request for good cause, but there will be very limited times when good cause exists. I honestly can't think of one right now, though. So Chair Dutton had a great question about what are the downsides. We don't see a downside to this. I'm sure someone could say something that they don't love about it, and we would love to talk with them about that and talk about how we can make this so that it will work for everybody, but so that every survivor in the state of Texas has the opportunity to request this option. And we encourage the committee to vote House Bill 698 favorably out. And I'm happy to answer any questions.
All right, thank you, Ms. Delgado. Thank you, and thank you for the organization and the work that they do. Members, do we have any questions? No? Thank you very much. Is there anyone else who wishes to testify on, for, or against House Bill 698? If not, the chair recognizes Chairwoman Criado to close on HB 698.
Thank you, Mr. Chairman, and thank you to the members and all the witnesses who came to testify. I'm excited about our Dallas legal bar that's going to be welcoming a new member. You did fantastic. And of course, to all the prosecutors who also came to testify. In sum, the speaker asked us to study it. This committee came up with a solution. We heard testimony even during the interim supporting this. This is a solution, and I hope request your favorable consideration.
Yes, ma'am. Thank you. It's a nice bill. Is there anybody else, any questions? If no objection, House Bill 698 will be left pending.
Thank you. Thank you.
Thank you. All right, at this time, House Bill 1884, Representative Bojani, you'll be laying out the bill.
Thank you very much, sir.
The chair lays out HB 1884, and the chair offers up a committee substitute to HB 1884. Okay, Representative Bojani, I'll explain the bill.
Thank you, Chairman Lujan and members of the committee for allowing me to lay out House Bill 1884. I would also like to introduce the committee substitute. The committee substitute to HB 1884 simply updates this bill as a legislative council draft. Members, the bill I want to talk to you about today passed this House last session with 144 votes. HB 1884 will ensure that everyone, regardless of their religious practice, can be married by their faith leaders. Current law authorizes Christian ministers, Jewish rabbis, certain officers of the religious organizations, and certain judges to conduct a marriage ceremony. This language creates confusion on who is able to ordain a marriage, resulting in hesitancy from religious leaders who want to ordain a marriage ceremony. HB 1884 resolves the issue by removing specific mentions of the ministers and rabbis altogether, but instead includes language clarifying that any person who is authorized by a religious organization can conduct a marriage ceremony. This ensures that all religious traditions have codified and equal authority to ordain a marriage. Members, this is a step forward in ensuring all Texans and their faith traditions are celebrated, respected, and protected. I'm grateful to my colleagues who have signed on to this bill to protect our religious freedoms, some of them being the members of this esteemed committee. Thank you, Representative Tallarico and Chairman Martinez-Fisher. At this time, I would be happy to answer any questions, and I would humbly request the opportunity to close.
Thank you, Representative Puccini. Anybody have any questions? Representative Tallarico?
Thank you, Mr. Chairman. So this bill got through the House with broad bipartisan support and died in the Senate. Is that correct?
That's correct.
Okay. Well, I'm so thankful that you're carrying it forward, and I hope we can get the job done this session.
Thank you for your support as well.
Members, anybody else have any question? Thank you, Representative Puccini.
Okay, thank you.
At this time, the chair will call up Jonathan Covey. If you can just let us know your name, organization, and how you be testifying your position.
Yes, sir, Mr. Chairman. My name is Jonathan Covey, Policy Director for Texas Values, and I'm testifying against the bill. And this is kind of unique in terms of why we're testifying against it, because we've testified against this bill every time it's come up because how it's drafted, and it strikes licensed or ordained Christian ministers and priests, and as a organization of faith, we just categorically can't support striking them out of the code.
Okay.
And we're willing to talk if there's another way to do this. I understand the intent of the author, I think, but we just can't support striking ordained Christian ministers.
Okay. Members, any questions? Representative Wilson?
Does the code currently not just authorize these two, but does it authorize other religious organizations to marriage, or does the only two the current law recognizes Christian minister and rabbi?
I saw Christian minister, rabbi, and priest, and then it has a section on the other authorized officers of religious organizations.
Would not a leader of any other church be an authorized?
We believe it's clear that leaders of all other churches should be authorized. I mean, I was just sitting here Googling before and pulled up the Islamic Society of Greater Houston, and they're offering to do marriage ceremonies on their website. So.
And they are authorized.
And they're authorized.
So, what, in your opinion, is the need to do this if the current code, or you don't?
We think it's clear. We don't think there's a need for it.
That it's necessary.
Yes, ma'am.
Because the code is clear that other religious faiths, their leaders can marry.
Yes, ma'am.
Okay. Thank you.
Thank you.
Members, any other questions? Representative Tallarico?
Thank you, Mr. Chairman. So your opposition to the bill is not that Christian ministers or priests would not be able to conduct marriage ceremonies. It's just that the words Christian minister or priest are no longer in the bill.
Well, I don't think that this bill would remove the authority from Christian ministers and priests to conduct marriage ceremonies. It strikes it out right there in the code. And that's something that we honor as an organization.
It strikes it out because it's included in this broader umbrella, so we don't have this confusion.
I understand that, but...
but you're still opposing the bill?
Yes.
But you understand why it's illogical to oppose the bill?
It's not illogical. We represent people of faith and Christian ministers. This states that in the legislation, it's kind of an honor. So we would oppose anything that...
So you remember this bill from last session? Do you remember who the author was of this bill?
I think you were.
I think I was too, yeah. And I had it to where we listed out certain religious officers who were not included. And when we got to the floor, some of the members thought this would just be easier, instead of listing everybody out, because we're always going to leave someone out if we make a list, to just create this broad category. Do you remember who wrote the amendment to that?
I don't. I think it was probably bipartisan, but I don't remember.
It was Briscoe Kane wrote the language that we're using.
Yeah, I know he's a co-author on this bill.
So I'm just saying, you had me and you had Briscoe Kane on the same page about that this was a better version, and that it would protect everybody, including Christian ministers and priests. But y'all are still opposing this bill.
For striking out that wording.
Because you like the words in there. Okay, I just wanted to double check. Thank you.
Thank you. Representative Wilson?
Yes, to your knowledge, and I'll ask Solomon too, to your knowledge, has this been an obstacle for other religions to marry people? Like,
Not to our knowledge. We haven't had this brought to our attention as an organization being an issue. But
so this, I'm just looking for why we're creating a law or that remedies something that is not happening. That's not an obstacle.
I don't know if that's a question I
Okay.
could answer.
Okay.
All right, thank you.
Thank you.
Members, anything else? Any other questions? Thank you very
Mr.
much.
Chairman.
Appreciate it. At this time, the chair calls Shamin Khan.
She had a flight and had to leave.
Oh, okay. Okay.
She'll be shown as representing herself and in support of the bill.
Okay. She'll be shown as representing herself and in support of the bill. At this time, we'll call up Jamelia English. Did I say that correct?
Thank you, members of the committee. My name is Jamila English, and I'm the legislative director for Engage Texas. And we uplift the political voice of the Muslim community and work for pluralistic democracy at home and abroad. We are testifying in support of HB 1884. The Muslim community is a growing demographic in Texas. Last session, Engage attempted to have imams officially named as individuals that can perform marriage ceremonies under the family code. So thank you, Representative Tallarico. Under Representative Bojani's leadership, you have the bill before you today. And although different groups can technically perform marriages, historically, when marginalized groups gain a more equal footing and gain in population, they are at risk of having fundamental rights stripped away. We see bills filed in this current session that do just that. And to be frank, after the Muslim ban came into fruition in this country, many in the Muslim community recognized that they had to shore up their fundamental rights. By solely having religious organizations designated to perform marriage ceremonies in the family code, the fundamental right to marriage is protected for all. We respectfully request the family code be amended and support HB 1884. Thank you for your consideration.
Thank you. Members, any questions? Yes, ma'am. Representative Wilson.
What rights did they shrug? I'm just.
The biggest concern that I have heard from our constituents is that the right can be stripped at any moment without their names actually being listed inside the bill. And so that's why last term we tried to have that happen. And I think the way that it's listed now is actually more inclusive for everyone. It doesn't change who can perform the ceremony, but it does not list anyone outright, and that protects everyone.
I understand that, but you said that rights had to be shrugged. So is that the word you used?
I said those words. Rights had to be shored up.
Shored up.
Yes.
Okay. All right. Thank you.
Thank you. Anything else?
Thank you, Representative Wilson. Anybody else, members? Any questions? Thank you for your testimony. Well, at this time, the chair calls up Mubin Komawala. He had to leave, okay. The chair calls up Sharik Ghani. Mr. Ghani, if you can tell us your name, organization, and how you stand on the bill, please.
Yes, sir. Today's been a long day. Good afternoon. My name is Sharik Abdul Ghani, and I'm in favor of HB 1884. I'm the executive director of Minaret Foundation, where we bring faith communities together through multi-faith and civic engagement. Marriage is a sacred act not only in the Islamic faith, but also for our Christian, Hindu, Jewish, and Sikh brothers and sisters as well. Along with my colleagues in the pastoral and the rabbinical community, it is a sacred moment in the milestones of our lives. And as it is said in my faith, when you get married, it completes 1/2 the portion of your life. Throughout Texas, imams, pastors, rabbis, and other faith leaders perform marriages on a daily basis as individual families come together to grow their love. Family is a cornerstone in all of our faith traditions, and it is a part of who we are as Texans. Adjusting this small portion of the code simplifies the language and ensures the religious freedom of all Texans is codified. Additionally, this is a bill that passed the House last session, and we would urge for you to please provide a favorable report for HB 1884. May God bless you all and allow this bill to become a light of hope and an inspiration for continued religious freedom in our state. Thank you.
Thank you so much. Members, any questions at this time? Representative Wilson?
Do you know if the law has ever just been more where they added the word imam rather than remove Christian minister and Jewish rabbi? Why would you not just add?
I have to tell you, my friend from Texas Values is up here, and we haven't actually formally met, but we're pretty big fans of Texas Values at our organization, at Minaret Foundation, just because of the religious freedom work that they do. When I heard that he was testifying against it because it removed Christian ministers out of the language, that I felt that, and I could see why that would hurt someone. What I would say to that is, when we add in and advocate for the religious freedom of all, sometimes we do have to take a step back to ensure that religious freedom for all of our Abrahamic brothers and sisters, for all faith traditions in Texas, is respected. To your question, ma'am, I believe if we add in imams, what ends up happening is that we end up excluding other organizations, other faith traditions out there today. I was testifying for a Senate Caucus organ harvesting bill today. I know that sounds completely irrelevant, but for that bill, when I spoke on the behalf of Muslims and Christians that are persecuted in China. What I inadvertently did was I left out Falun Gong, who are actually significantly impacted by the actions of the CCP overseas. So when we solidify this language and we make it almost neutral in a way to ensure that it respects our Christian brothers and sisters, our Muslim brothers and sisters, our Jewish brothers and sisters, but people of all faith traditions, I believe it's a positive step forward for religious freedom, but it also gives a shining light for other states to do the same thing as well.
Okay. Thank you.
Thank you, ma'am.
Very good. Members, any other questions? Thank you so much for your testimony.
Thank you, sir. Appreciate it.
All right, is there anyone else who would like to testify on, for, or against House Bill 1884? If not, the chair will call and recognize Representative Bojani to come and close on HB 1884.
Thank you, Chairman and members, for allowing me to close. I thank you, Representative Leo Wilson, for your questions. I think everything, I can sum it up in a way that everybody wants to see their name, their faith in law, right? And that desire to see your own faith in law is so much. That is what caused an opposition for this bill right now, right? Because to strike out Christian ministers or Jewish rabbis. But if the shoe were on the other foot, which is happening right now, there's never, ever been a Muslim representative ever elected in the history of the state of Texas. So as a colleague of yours, I'm saying, is my religion respected within the State House? And should I only be selfish to say, let me add Muslim imams to this list, right? And that would be a logical way to say, let's keep Christian ministers, let's keep Jewish rabbis, let me just add my religious leaders to the list. It would be so selfish of me to do that. And my faith inspires me and tells me to be inclusive, to be fighting for those that do not have a voice. And so I'm fighting for the Hindus, for the Buddhists, for all the other religions that I am not familiar with in the state of Texas, but there are people that exist in the state of Texas that would like their religious leaders to ordain a marriage for them. And this is something that nobody would argue that if a Buddhist monk wanted to get married or have two Buddhists get married, no one here will ever object to that. What happens, practically speaking, is I'll give you my example. I was married about 18 years ago. It's coming up to be 19 now. And I have to, so it's very difficult. I mean, for maybe the men here that can maybe relate to it, it's very difficult to remember that wedding anniversary, right? The date. I have 2 dates. I was married in the court, and I was married in my mosque. And so I have to remember 2 dates every single year. I still remember it, but and I'm glad, but it's very ambiguous right now. It's very confusing right now. Like, I've gone to my imams in my mosque, and they're like, oh, no, we can't perform weddings. I mean, we can perform weddings in our mosque, but not as a seal of state of Texas, right? And so there's a lot of ambiguity. Same thing with the Hindu temples. Buddhist monks that are in the state of Texas, they don't realize that they can actually perform weddings, right? Because, again, there's not been an advocate there for before, right? You don't see organizations coming in again and again and saying, hey, what about Hindus? So I feel like that's something that's really important to think about, right? That if we start listing, I'm happy to do that. If Texas Values want it, I'm happy to do that, and that is exactly what Representative Talarico did last session. He listed out everybody. He kept Christian ministers there. He kept Jewish rabbis there. But at the end of the day, it's also, I can see how it can be difficult to see the word Muslim imams there for some people, right? And so this allows it in a way that it's inclusive. It fights for the religious freedom for every single Texan. And that's why I think this is a better version, in my opinion. But I'm happy to do whatever it takes. You see, the intent of that is that, when you start a list, you will always have the danger of missing somebody out. Does that make sense?
Yes, it does make sense. But I mean, educate me on that. If an imam marries you and is authorized to marry you, then you also have to do it in court? Or that's not recognized by the state of Texas unless you go to court? So you have 2 dates because authorization doesn't allow you to do both or to recognize the one in your mosque.
I think the Muslim community leaders, the imams, and like I said, even in temples, they don't even realize they have this power. Because when they look at this statute, if they look at this statute, they'll say, okay, it's Christian ministers clearly stated, Jewish rabbis clearly stated, and then other officers of other religious organizations. So they'll be like, I'm not an officer of a religious organization, maybe it doesn't apply to me. And so I'm not saying that there is anything wrong with the statute currently, but what I'm saying is, like the opposition that we heard, that they don't like the fact that we're striking out Christian ministers. Why is that the fact? Because if you strike out Christian ministers and if you strike out Jewish rabbis, the act will do the exact same thing, or the law will do the exact same thing. But it's like I said, I started with that, right? Everybody wants to see their faith in law. Everybody wants to see their name on there, right? And so that's where we're trying to protect and balance naming everybody or making a general statement that all religious leaders can ordain a marriage, making it even more simple. And that actually idea, like Representative Talarico said, came from Chairman Briscoe Kane last session. And he's a joint author with me on that just because of the fact that we adopted his own amendment on the floor. So this made it more palatable for all members to say yes. 144 members said yes to this because it made sense to them, saying that, okay, any religious, we're not leaving anybody behind, right? There may be another religion, like India has a lot of religions. Maybe there's people that come here from Zoroastrianism or Jainism. And I know a few people from them, but how do we add all of them? Like, there's no encompassing, like rabbis is different word, priest is different word, imams is different word, pandit is different word for Hindus. So how can we come up with all these exercise of adding every single faith in there without fear of missing somebody? And so when I think about religious freedoms, I feel like our state should fight for religious freedom for everybody, all Texans. Don't leave anybody behind.
I understand that. I absolutely do. It's just hard for me to, like you said, just be somebody that strikes my own religion. I mean, that's what it'll be interpreted as, even though it's all encompassing.
Sure.
So,
Well,
yeah.
thank you for being honest. I totally understand that concern, and
Yeah.
like I said, I'm happy to make amendments to this, or give another committee substitute if y'all want to look at that. But I just feel like it'll be the same thing next time somebody else gets elected that is a different faith. They'll say, "Hey, Salman or the state reps, why did you miss my religion when you had the opportunity to?" So it could be an over-exhaustive list, or it can be a simple sentence. And I mean, we can talk offline as well and try to figure that out as well.
Thank you.
Thank you, Representative Bojani. Anybody else? Any other questions? Are you finished closing?
I just want to quickly talk about the witness that was there, Shameen Khan. Actually, she also told me she was married 20 years ago, 2 years before me, and said that she had to get married twice because she went to the imams and they said, no, we can't do it. You have to go to the court first and get a court certificate, and then we'll get you married. And so that was going to be part of her testimony as well, that it's a lot of confusion within a lot of different faiths that want to do the right thing, but they don't, because they don't have the ideas.
Thank you very much, Representative Bojani. The committee substitute is withdrawn, and if there's no objection, HB 1884 will be left pending. Thank you.
So I have to close. Ask for favorable consideration. I close. Thank you.
Okay. Thank you. All right, at this time, we'll be doing HB 924. Representative Rosenthal.
I would vote for that bill. Thank you, Mr. Chairman, for allowing me to lay out House Bill 924. I'm standing here today in an effort to end child marriage in Texas once and for all. And I hope that this kind committee will help me do it. So I do have a... Go ahead. Sorry. So I don't know if you are aware that it is still legal for minors to be wed in this state. According to a group called Unchained at Last, a nonprofit advocacy group dedicated to ending forced child marriages, over the last 8 years, more than 42,000 minors have been married in the state of Texas. In 2017, this legislature passed a bill that did reduce child marriage, set a minimum age at 16. Prior to that, there was no minimum age for girls to be married in this state. We got records over the last decade of girls in Texas being married as young as 12 years old. So even though we took a step in the right direction in 2017, a loophole still exists. In Texas, children can still be coerced into child marriage with the emancipation of their parents as young as 16 years old. Roughly 96% of minors married in Texas were young girls married to men significantly older than them. It undermines statutory rape laws. It's gone completely unchecked, even with the measures that we took in the 85th session. Minors and child marriages report high rates of physical, sexual, financial, and emotional abuse. Studies show that over 80% of child marriages end in divorce or a child seeking refuge in a domestic abuse center. This legislative session, we have had a tight focus on protecting our families, on protecting our children. So why would we continue to allow them to be married off underage? It's time that Texas stops ignoring their youth. 10 other states have already banned child marriage in all situations. It's time we do that. So with that, I know we have at least one witness, and I'd like to reserve a right to close.
Okay. Thank you, Representative Rosenthal. Any questions, members? No? All right. Chair will call up Natalie Arroyo. So you can give us your complete name, who you're with, and your stance.
Great. My name is Natalie Arroyo. I am here on behalf of the AHA Foundation, but also as a mother in Texas and a lifelong Texan. I just want to thank you guys for hearing me speak about this really important issue, and thank you to Representative Rosenthal for his leadership. Like I mentioned, I work at the AHA Foundation, and we are a nonprofit founded by a survivor of forced marriage, and we work to end child forced marriage and other harmful practices in the U.S. And this does include fielding requests of assistance from forced marriage survivors, including minors. As Representative Rosenthal mentioned, under the current state law, the age required to marry is 18, but there is a loophole that allows emancipated 16 and 17-year-olds to get married with parental and judicial approval. As he mentioned, 41,774 children were married in Texas between 2000 and 2018, and 96% of those were girls wed to adult men, which is what we see very frequently. Even after the current law went into effect, preliminary state data shows that at least one minor was married in 2018, proving that child marriage is still happening in Texas, and HB 924 will keep the marriage age at 18 and close this one remaining loophole. Marriage before the age of 18 is a human rights abuse. It destroys nearly every aspect of a girl's lives, including health, education, and economic opportunities. A minor who marries before 18 is much more likely to not finish school, live in poverty, and suffer serious mental and physical health consequences. It also significantly increases their risk of experiencing domestic violence. Emancipation does not negate the negative effects that 16 and 17-year-olds will face if they get married. I'd like to now highlight why this specific loophole is so dangerous and why we need to close it. We and other advocates see often that perpetrators of forced marriage are almost always parents. So minors can be coerced into marriage by their family, and they may fear violence if they refuse to comply, or that they may be physically and emotionally manipulated into accepting this unwanted marriage. The 2017 law removed one of the only avenues that we had to help teens escape parents who are trying to force them into marriages, specifically taking them overseas for a forced marriage. This was an issue with one of our allies who was unable to help a teen here in Texas who is being taken abroad for a forced marriage because after the law went into place, they could just emancipate their child here and facilitate the marriage. Had there been no loophole in place, this teen would have had 2 more years to finish their school and choose their own path in their life. This loophole undermines our statutory rape laws. Sex with a 16-year-old is a crime if the perpetrator is more than 3 years older than the minor, unless the perpetrator first marries the minor. A marriage license in this case is a get-out-of-jail-free card for the would-be child rapist, and I don't think that's a great reason we should be emancipating children in Texas. As Representative Rosenthal mentioned, other states have already taken action and are setting the minimum age of marriage at 18 with no exceptions, and we don't want Texas to be left behind. The U.S. has made a promise to end child marriage by the year 2030, and we just can't emancipate our kids and marry them off and pretend like it doesn't happen. So I'm here today, like I said, as a representative, as a mother, as a citizen in Texas, to ask you to vote yes on HB 924. And I handed out some written testimony that goes into more facts, but I'm more than happy to answer any questions as well.
Ms. Arroyo, thank you for your testimony. Members, any questions? Thank you so much.
Thank you.
Did you have one?
Yeah.
Go ahead.
Well, I'm just a little bit concerned. My mom had me early and wouldn't have been able to marry my dad under your provision. I have a friend whose father was a pastor, and actually they married at 17, and they've been married 50 years. So, I don't know. When you create that, you're also prohibiting people who are not in an abusive situation or not being forced, but want to get married and want to get married with good reason, like me. So,
Yeah, I think that's definitely valid. And I would just say the health consequences physically and mentally that do plague women who get married before 18 still even, can apply to women who are choosing to get married. There's actually really interesting research that shows like heart problems and things that you wouldn't even associate with early marriage. But in all honesty, the way that I feel is I also have anecdotal stories of people who, got married and had really terrible endings. There's a woman named Sherry Johnson who was forced to get married at the age of 8 because a minister at her church raped her and she became pregnant. And so police began investigating. And unfortunately, they decided to go down this avenue, which even they shopped different courts. So a judge said, no, I'm not going to allow this to happen. And so they just went to a different courthouse in Florida. So I definitely think that, in the past we've allowed this. And like you're saying, it's not always a case of abuse. But from my perspective, I think, unfortunately, if some people have to wait another year to enter into a relationship that they want to legally, I think I'm willing to let that go in order to protect, children who may be in this situation and aren't.
what is the age in Texas
Right now,
with
it's
parental permission?
you have to be emancipated 16 and
16,
17-year-old. Yeah.
17,
So other than that, children under the age, the 2017 bill took care of that.
Okay.
But at AHA Foundation, we always push for no exceptions because we just want everyone to be able to make that decision for themselves.
Okay, thank you.
Yeah. Thanks.
All right, members, any other questions? Thank you, Ms. Rojas, for your testimony. Okay, that's all. Anybody wanting to testify? Is there anybody that's on for or against HB 924? All right, hearing none. Chair recognizes Representative Rosenthal to close.
Thank you very much. So I do want to address your question, Rep. Leo Wilson. No one is saying they can't marry. They're just saying wait till they're 18 to make it legal. So no one is saying you can't get married. You just inferred that they couldn't get married. And I think that's enough for me to say about that. For the rare cases that it actually works out, I'm grateful for those families and those family units. Statistics show that more than 80% of marriages that start with one of the partners being underage end in divorce. It's never, divorce is never a desirable situation. It's hard on everybody. My parents got divorced when I was a teenager, hard on the family. So with that, unless you have any other questions, I would pray for your favorable consideration. I hope you will help me finally end child marriage in Texas.
Any questions, members?
That I close.
Thank you, Representative Rosenthal. If there's no objection, HB 924 will be left pending.
907.
All right. At this time, the chair lays out HB 907, and the chair recognizes Chairman Moody to explain the bill. All right. Go ahead, Representative Moody.
How are you doing? Thanks for having me. This pretty simple bill actually goes to, I think, actually goes to the point of why having a laundry list of things in a statute is not a great idea. When I originally had this bill, there was a new class of judges that we created, and the way that we've done marriages and judges performing marriages is whenever we create a new kind of judge, we have to come back to the session and then qualify them to be able to perform marriages. So new judge created by statute, then you come back to the following session, that judge says, hey, why can't I conduct a marriage ceremony? Well, we need to add you into the statute. So the way the statute reads now is a laundry list of judges. Every type of judge we've created in the history of time has had to be added in over and over and over and over, like as this goes on. So what we did was said, why don't we just future-proof this and say, if you add a new type of judge, they get to do a marriage, because that's what happens anyway, functionally. So it just future-proofs it, it does cut off work for a future legislature to have to do that, but I think that's okay. So it's as simple as this bill gets. There's been some confusion initially when we did this a few sessions back about what we were trying to get to, because it struck so much from the code, but it's actually just to make it automatically qualify them when the legislature decides to create a new type or a new class of judge, they get automatically added over here. So no need to have two pieces of legislation.
Excellent. Thank you. Representatives and members, any questions? No? I thank you very much. Representative Moody, if there is no witnesses, anybody want to testify on, for, or against? If not, okay. If there's no objection, HB 907 will be left pending.
I appreciate that. Thank you. And I think based on the work we've done on this in the past, I think we've got it to a very comfortable space. If y'all feel comfortable when you vote on it, we're sending it to the local and consent calendar. That would be great.
Thank you so much.
I'll leave that to the chairman's discretion.
All right, at this time, we'll be laying out House Bill 3431. The chair recognizes Chairman Dutton to explain the bill. Thank you, Mr. Chairman. Members, currently, state law does not adequately address situations involving fraudulent acts to assert jurisdiction. Family law is a complicated matter, to say the least, because it often involves more people than just parties to the divorce case. For example, there can be children, extended family members, as well as former spouses who can be affected by a divorce decree. Likewise, spouses who marry an individual who has obtained a fraudulent divorce without the court having proper jurisdiction build community property estates only to discover later that the basis of their underlying marriage was fraudulent, and the partnership between the putative spouse was not effective and based on fraudulent or incorrect assumptions. House Bill 3431 would authorize the court to consider an affected non-party to challenge the underlying jurisdiction in divorce cases when a party to the divorce has engaged in fraudulent acts or omissions to purposely obtain Texas jurisdiction. That's all this bill does. I will be happy to answer any questions to the extent there are any. Members, are there any questions?
I don't know if there are any witnesses.
All right, at this time, we'll be calling up witnesses. Matthew Hill.
Good afternoon, members of the committee. My name is Matthew Hill. I'm a family law litigation attorney from New Braunfels. I'm speaking in that role. I'm also the president of a nonprofit called Texas Concerns for Family Law Justice, and I'm speaking as the president of that organization today. Thank you, Mr. Chairman, for presenting this legislation. This is needed to get Texas in line with some other states, particularly Georgia and California, which allow people that develop a community property estate over the years on the basis of belief that they had a legal, legitimate marriage to protect that and have a remedy, a much simpler remedy than there exists at this point in time, to go back and challenge that, so that the community estate that they developed actually is theirs and is not subject to some other courts or out-of-state jurisdiction. I'm happy to answer any additional questions at this time if there are any. And again, I thank the committee for allowing me the time to come and testify today.
Mr. Hill, thank you. Members, any questions? None? Thank you so much for your testimony. Appreciate it. This time, the chair will call Heather King. Yes, ma'am. Go ahead.
Mr. Chair, Mr. Vice Chair. Hello. My name is Heather King, and I'm a board-certified family law attorney for very scarily almost 20 years now, licensed since 1995. I'm also an executive on the Texas Family Law Foundation, the vice president, and I come here in my capacity as a family law attorney and in my capacity on the foundation. The first thing I want to do is absolutely thank Texans concerned for family law justice.
Oh, I'm sorry. Are you on for or against?
I apologize. I had a little list here to say that,
Yeah.
and I completely missed it. I'm here to testify in favor of
Okay, thank
House
you.
Bill 3431. And I want to thank the Texans Concerned for Family Law Justice, the TCFLJ. We've worked together on this bill. We have drafted together on this bill. And although in legislative speak, I can't speak to whether there are any more changes to be made, but I can say that as early as a few hours ago, we were working together on the bill. And to the best of my knowledge, we have agreed to all of the changes that would otherwise be placed on the bill. They were very kind in allowing me to express any concerns I had and what needed to be placed in the bill, and we have done so. So I stand here in favor of this bill, which I do believe would allow a court the opportunity to consider whether the development of community property is something that occurred in, I'm going to use, a fraudulent nature, okay? And thereby determine if they want to void the marriage, and those of us that went to law school, I'm not going to try to do the void and voidable thing, but for those of us that went to law school, if the marriage is voided, to give the court the opportunity to give consideration to the fact that community property that was community property, that is presumptively community property, had developed over a period of time, even during a marriage that was otherwise putative to a putative spouse.
Thank
I
you.
welcome any questions.
Thank you, Ms. King, for your testimony. Members, any questions? No? Thank you very much.
Thank you.
Is there anyone else who would like to testify on, for, or against HB 3431? If not, the chair recognizes Chairman Dutton to close on HB 3431.
Thank you, Mr. Chairman. I close.
Okay. If there's no objection, HB 3431 will be left pending. All right. This time the chair lays out HB 5291, and once again, we'll recognize Chairman Dutton to explain the bill.
Thank you, Mr. Chairman, and members. When the pandemic hit and the Texas Supreme Court issued its emergency orders, Texas courts were told that accepting out-of-court sworn statements as evidence was explicitly permitted. Now that the pandemic-based emergency orders have terminated, courts are under the impression that that power has also been taken back by virtue of the termination. Even prior to the pandemic, however, Texas courts could take up agreed family matters in the manner proposed by this bill. However, this was not the norm, and many courts did not realize they had such authority. Currently, state law does not adequately or clearly provide for the submission of out-of-court sworn statements in support of agreed final orders. What this bill proposes to do is to allow parties a simple way to finalize agreed divorce cases without requiring them to confront each other in court or forcing them to take off work and pay their lawyers for a hearing, which is just a formality. House Bill 5291 would explicitly require court to accept agreed divorce orders for entry by submission of evidence rather than requiring a party to attend court in person with their attorney simply to finalize an agreed case.
Thank you. Members, any questions? No? This time the chair will call up Matthew Hill. Once again, your name, you're representing, and on, for, or against.
Yes, Representative Lujan. My name is Matthew Hill. I'm a family law litigation attorney from New Braunfels, Texas. I'm also the president of Texans Concerned for Family Law Justice, and I'm testifying in favor of this bill. As Chairman Dutton eloquently mentioned, during the pandemic, agreed orders were routinely entered by submission by virtue of the Supreme Court's emergency order. When the pandemic and the emergency orders ended, many courts believed that that right was taken away, or that power was taken away. And in fact, it was not. It was the power that the courts currently have, that they have always had, and just many courts didn't exercise the option to utilize that vehicle. This bill would allow agreed orders to be presented by submission and saving Texans money because they're not having to pay their attorneys to travel to and from the courthouse or wait around at the courthouse if it's a criminal docket day and you don't get reached until the afternoon. Someone's had to pay their attorney all day for what, frankly, is a hearing that lasts less than I'm going to be testifying right now. So it's a cost-saving measure for Texans. It's also a court docket saving measure because it reduces the number of hearings that are going to have to be held in court. We've worked very closely with the Family Law Foundation on this and worked out language. And the bill, frankly, is in a very good state. And I very much believe it's appropriate and is important for the legislature to put forward. Thank you for your time. Thank you, Mr. Chairman, for presenting it, and thank you for the time to testify.
Thank you, Mr. Hill. Members, any questions? Thank you very much. At this time, the chair calls up Ms. Heather King. Same thing, Ms. King. Name, who you're representing, and on for or against.
Thank you for reminding
Yes,
me.
ma'am.
My name is Heather King. I am here as a family law attorney individually and also as vice president of the Texas Family Law Foundation. And again, want to thank Texas Concern for Family Law Justice with the work we have done together on this bill, which I'm here in favor of. And I would like to point out that again, we're looking at this and making changes up to the last few hours. So I'm going to assume and speak to you on the basis of those changes, which most likely are not reflected. First, I want to echo the words of my predecessor presenter and say that this is a most excellent bill in the context of saving money for litigants so that they don't have to drive to the courthouse. Many attorneys, particularly those who travel a long way, are charging for travel time. They might be charging for mileage. Then they're charging for waiting time at the courthouse. And all of that will be eliminated by virtue of some type of rule that will allow, or at least make it clear, that judges understand that they have the ability to do this. And I want to point out, Chair Dutton, the author of this bill, that the Texas Family Law Practice Manual has already prepared and inserted in their form book forms for these affidavits and declarations. So they exist, and they are ready for people to use. And we got together and pulled out the necessary absolutes from those form books to help clarify the statute to make sure that the stuff that has to be said is said. But attorneys are now able to open up their computers and find these affidavits or pro se parties and literally put their names in. So this can be done very easily, and if the court believes that for whatever reason there's a complexity that needs the opportunity to be heard in person, they have the ability to do so. So I would testify in favor of this bill, and I thank you, Chair Dutton, for authoring this bill.
Ms. King, thank you very much. Members, any questions? Thank you very much. All right, there's no more witnesses. Is there anyone else who wish to testify on, for, or against HB 5291? Not, the chair recognizes Chairman Dutton to close on HB 5291.
Thank you, Mr. Chairman. I close.
There's no objection. 5291 will be left pending.
Chair at this time lays out House Bill 503 and recognizes Representative Wu.
Thank you, Mr. Chairman. I'm going to keep this pretty quick. This is a bill that we actually passed and got to the governor's desk last time, and we had a little bit of a policy difference with the governor's office on it, and ended up getting vetoed. But we're going to try again, and we're going to try to modify it down to do less and make it less objectionable. We do have a committee substitute.
Okay, the chair at this time lays out the committee substitute to House Bill 503 without objection. So ordered.
Thank you. So here's what we're doing. I don't know how much background we need on this. So for members who don't practice juvenile law, there are several kinds of sentences a child can get, but they're mainly broken down into two categories: either a indeterminate sentence, right, or a determinate sentence. A indeterminate sentence basically is like what it sounds. It's technically like it can go If it's usually for like a 1-year probation or something like that, but it can extend further than that if you're not doing well. It could be less than that if the judge wants it ended early. And indeterminate sentences, the biggest difference between that and determinate is indeterminate sentences can be sealed. They can be sealed up, and a child can have a second chance. A determinate sentence has to go through a grand jury. It has to be presented to a grand jury. Grand jury stamps it. Sometimes people might call it a rubber stamp, but whatever. And says that is a determinate case. The biggest changes on a determinate case as compared to indeterminate is a determinate case can carry a sentence that's past the length of the time of the court's jurisdiction, meaning that if on a normal probation case, all cases must end at 18. An indeterminate case must end at 18. As well as incarceration. Incarceration in an indeterminate case must end at age 19 because the court's jurisdiction ends. So that day, you can't do anything else, right? So if children are charged with serious offenses, sometimes the DAs will take their cases to the grand jury and make them determinate cases. That means that if a child is, like, say, 16, and they can be now sentenced to a 5-year term in either on probation or being locked up, and before that jurisdiction ends, a court has to have what's called a transfer hearing, and the court will decide whether or not a child needs to be transferred into the adult system, meaning that if they're locked up, they'll be transferred into TDCJ or be put on parole or a number of things. If they're on probation, decide whether or not to transfer their probation into adult probation. That's it, right? The second big part of it is your record is now public. Your record cannot be sealed once it's determinate. Your record follows you for the rest of your life. So something that you did at, let's say, 15, 16, can follow you and affect you for the rest of your entire life. So, we're hoping most people live long lives, and that's going to be a significant amount of time. So, there's a lot of study and a lot of common experience that says, like, when kids have incentives to do better, they tend to do better. And part of the reason we're trying to provide this is an incentive to have your case sealed, is that they try harder on their probation. They try harder when they've taken a determinate conviction. And the idea is that with this substitute, so the difference between the substitute and the original bill was what got vetoed. The substitute removes all incarceration, right? So if a child gets a determinate case, the judge can sentence them to either be on probation or be incarcerated. And in the past, we allowed both to be sealed. This new substitute only says if they were put on probation. So that means that they did not go to or were sentenced to TJJD or youth prison. That's it, right? That's the big difference. There is a provision of this bill that last time when we negotiated this bill was sort of the exchange. And there is a provision in this bill that says that essentially says that if a child is past the jurisdiction age, the DAs can keep prosecuting the case. In the past, and the current law is that they can only keep prosecuting the case if they were completely not at fault, right? And the old statute says that the prosecuting attorney has to show that they exercise due diligence in attempting to complete the proceedings before the respondent became 18 or 19. We added an additional safety valve for them that says the proceeding had been delayed through no fault of the state. That was put in there as sort of a exchange between the stakeholders, right? So, and so this bill still has a little something for everyone. So whether you're pro prosecution, pro defense, there's something for everybody here. But the ultimate goal is we want to maximize and encourage kids who get sentenced to these sentences to give them an incentive to do well. But if they do well, have the actual ability to petition the court, not be granted automatically, but to actually petition the court, to ask the court, and the prosecutors can object, to have their records sealed so that they could actually maybe go to college, so they can possibly join the military, so they can get licensed to do other professions and a lot of things. So it doesn't completely ruin their lives. It's still there. The records are still there. They're just not visible to everybody, right? And so, and again, the way this bill reads is if the judge does not transfer the case, then it can be sealed. If a judge transfers the case to adult side, it can't be sealed for a lot of practical reasons. But legally, if a judge does not transfer a case, what the judge is actually saying under the law is this child is now fully rehabilitated and there is no need for any further rehabilitation. So, again, if a child is fully rehabilitated under the juvenile system, as the law wanted, then give them the same opportunities to seal the records as everyone else. That's it, and I'm happy to take questions.
Any questions? I think there are a couple of questions. Vice Chair Luan.
Representative Wu, do you think that the issues that why it got vetoed, have those been mitigated fully, do you feel?
I can't, I was been specifically not to talk about back sort of like our negotiations, but we believe so.
Okay.
All right.
Leo Wilson.
Would that be applicable to like violent crimes? Like, okay, let's say somebody hurt their grandmother or whatever.
Yeah.
And I mean, in a serious fashion, got probation. Would that take them in too? I mean, I'd want to know if it was a violent crime.
Yeah. So it would include violent crimes, right? But again, our distinction is whether they got on the substitute is whether they got probation or whether they got TJJD, whether they got probation or prison, and that's a big difference because based on the statutes, when judges do sentencing, what they're looking at is what is the proper environment for this child, right? If the judge says, let's say it's a robbery, right? I've managed a lot of robberies. You have a child who held up a gas station, and on the video you see them like they fumble the gun and their hands are shaking and they just kind of like walk in and they kind of like show their gun and they just walk out. Nobody was hurt. Nothing has happened. But that's an aggravated robbery, right? First degree felony. But the judge looks at the evidence and says, look, this is a violent crime, right? This is a violent crime. But based on this child's past history, what actually happened during the robbery, and the nature of and how this child has done, I'm not going to sentence them to that. Incarceration into TJJD is not necessary for this child, right? It was a one-time mistake. They're working on it. This child is otherwise maintaining like good grades, going to school, doing well, and it's not necessary for the rehabilitation of this child to be placed into prison. But we're going to put them on probation, right? And those kind of considerations are taken all the time.
My worry is we have judges that are letting people out on probation who have committed violent crimes and they commit them again. And so, I mean, it depends on the judge. And that's where I'm a little bit nervous about it. I get your situation, and I don't like when offenses follow minors into adulthood and continue to haunt them, so to speak.
Yeah.
But if it was a violent crime, to me, that's
And this is where, so here's the part that relieves your concern. This is not a shall, right? This is a may. So when somebody says, let's say this follows the situation. Let's say you have this kid who committed a first degree aggravated offense.
Is that may, though, in the hands of a judge?
Yes. But let me show you how it would work through. So let's say this child is put on probation, and while they're on probation until they're 18, and they were on probation for 2.5, 3 years, whatever it is, they're just absolute rock star. They went to school, they got on dean's list, they did everything they're supposed to do. They completed all their community service, completed all their services in the first 6 months, right? And they just knocked it out of the park, and they're doing well. After all this, after they're completely done with their probation, everything is done, and the judge decides not to transfer their case into the outside, say you are fully rehabilitated, we believe there's nothing else to do. If that occurs, which is not always, which is relatively rare, they would submit an application, because it's a felony, they would submit an application to seal. The application to seal is not guaranteed, and it's far from it. They have to notify the DAs. The DAs get to have a say. Hey, judge, this was a violent offense. We should not seal this, right? Or this kind of offense. We should not be sealing this. And then we would present evidence on it, talk about it, present witnesses, and the judge would make a decision. And what is in the best interest of this child? What is in the best interest of society? And there's a lot of times when we have cases where, like, hey, we think everyone should have a second chance, but this child is violent, or this child is a sexual predator. We should make sure those records are known, and we do that all the time, right? And my only thing is I'm just asking y'all to trust your DAs, trust your judges. I know sometimes there's cases out there where people go, well, that seems really off, but like if you actually go and look at the actual facts surrounding those cases, find out about what actually happened in the case, talk to the attorneys involved, and you go, oh, okay, that actually makes sense, right? And so I'm asking everyone to trust the people who you put in charge of doing these things. They know what they're doing, and frankly, from my experience, they do it very well. Oh, I'm happy to talk to you outside of this as well. If you.
Okay. All right. Any further questions? I don't think so, and they did not. Oh, yes. Alicia Castillo does not seem to be here. She is the Director of Policy and Analysis for the Texas Center for Justice and Equity. She was testifying for herself and the center, and she was for the bill, but she will be shown as not having testified, but for the bill. Is there Julie Wheeler? Is she here? She doesn't appear to be here either.
This is the new strategy.
She was with Travis County Commissioners Court. She was here to testify for the bill as well. She will be shown as for the bill, but not having testified.
Right there.
Roberto Lopez, chair calls Roberto Lopez. He was with the Texas Civil Rights Project and testifying for the project and himself. He was for House Bill 503. He will be shown as not having testified, though. Ashley Harris doesn't appear to be here either. With the United Way of Texas, she was for the bill, and she will be shown as not having testified, but for the bill. Amanda List with Texas Appleseed. I don't see Ms. List. She was for the bill also, but she will be shown as not having testified. And that is all of the witness affirmations I have. Is there anyone else here who would like to testify on, for, or against the committee substitute for House Bill 503? Not hearing any, the chair recognizes Representative Wu to close.
Yeah, thank you, Chairman. And I'm happy to work with any members, but I just want to remind us that we passed a bigger bill that did more overwhelmingly by very, very large margins last time, and passed that out of the Senate as well. And this is this is legislation that that is a compromise with all the stakeholders in this arena. So with that, I close.
All right. The chair withdraws without objection the committee substitute for House Bill 503 and leaves the House Bill 503 as a matter pending business before the committee without objection. Chair hears none, that's so ordered. Chair at this time lays out House Bill 660 by Representative Cook.
This is the pile of Cook bills.
There is a committee substitute. The chair at this time lays out the committee substitute for House Bill 660 without objection and recognizes Representative Cook to explain it.
Thank you, Mr. Chairman. I appreciate the opportunity to lay out House Bill 660. Members, offer this bill to you as a result of the Juvenile Justice Family Issues Interim Committee that Chair Niabi talked about earlier today in her testimony. I was selected to be on the interim committee by Speaker Phelan and enjoyed the opportunity to learn more about protective orders. As you've heard today, there's been lots of protective order bills, and they're very important for the protection and safety of victims. And so this bill is quite simple. These are some of the issues that came from testimony, primarily from the Tarrant County District Attorney's Office. There's a primary district attorney there in Tarrant County that is very well known for prosecuting and pursuing protective orders on behalf of victims. Her name is Marvina Robinson, so I certainly want to give Marvina, I should have named this law in her honor, but because she certainly brought these ideas to us, and we had them in separate bills, but decided just to put them all into one, and that's what we have laid out in committee substitute for House Bill 660. The three components, the first one makes a change to Section 83.0025, which is the enforcement of a temporary ex parte protective order. Based on the testimony we received in the interim committee, there have been instances where law enforcement are not giving the same full force and weight of the law to an ex parte protective order as they are a protective order. And this provision of committee substitute to House Bill 660 makes it clear that it has the same extent and same manner as a final protective order rendered under Chapter 85.
Let me ask you, I wonder, what were they doing differently?
Well, Mr. Chairman, I pondered the same question, but basically what she was even receiving phone calls from police departments and saying that they've been instructed, and their interpretation is that an ex parte temporary protective order does not have the same authority and weight as a protective order that's granted for a year or two. And so this is meant to make it very crystal clear that the legislature's intent is that an ex parte protective order that's properly granted under the Family Code is enforceable as the same as a protective order.
Well, thank you for that, because I just, when I read the bill, I couldn't figure out what would they do differently.
That was my response as well, Mr. Chairman.
All right, thank you.
Next is changes made to Section 86.001 of the Family Code, and these deal with primarily notification. So currently, a law enforcement agency may enter the protective order into the agency's computer records of outstanding warrants, and so you kind of imagine a police officer, pulling over a vehicle or approaching a suspect, whatever the case may be, and when they're identifying a suspect or even just a routine traffic stop, it's good for that officer to know when he or she is approaching the vehicle that this person has a protective order issued against them. And so what this says is that the law enforcement agencies must or shall enter the protective orders into their records so that it'll come up the same as if an outstanding warrant was being pulled. So that's Section 86.00B, that's the change there. And then Section 3 is dealing with Section 86.0011A of the Family Code, and it's amended to read that the time needs to be sped up to where these law enforcement agencies are entering the protective orders that need to be the next business day as opposed to the third business day, because a lot of times, if there is going to be violence or violations of protective order, often they're immediately after a protective order is granted. And so the intent here is to get the notice out quicker. And then the last section, Section 4, deals with Section 87.004 of the Family Code, and it simply says that if a protected person moves to a different county and they notify the clerk that their address has changed, and the clerk now is going to be ordered, and they shall deliver a copy. Like, so, for example, if someone lived in Arlington, Texas, got a protective order in Tarrant County, they moved to Travis County, then the clerk's office in Tarrant County, if they were notified of a change of address by the protected party, then the clerk has a duty to then notify the Austin PD and the Austin Sheriff's Department, as the same as they do at the beginning of a protective order. So those are the updates that, again, Marvina Robinson brought to us in her testimony over the interim, and offered those as good policy for the state of Texas, and would appreciate your favorable consideration.
Okay.
And
Any questions of Representative Cook, members?
I got one question.
Representative Lujan.
Thank you, Chairman. Then, what holds the departments to say they don't comply? What? I'm just curious. What enforces that?
I think it'd be a matter of who would enforce it, and I would think that if locally would be the first first instance. So like I think if District Attorney Robinson received a phone call from a local chief or a local police officer, she would be able to point to these sections of the law, and then if there was no compliance there, then I would expect that a district attorney would handle it within their office and move forward with trying to enforce it. Otherwise, ultimately, obviously, I think the Attorney General's office would have the ability to enforce it ultimately. I mean, obviously, this bill doesn't provide for that, but as far as enforcing the provision, I think they would have the ability to do it as well. But I expect that it would be handled within the county.
Okay, thank you.
All right. Any further questions of Representative Cook, members?
And I don't know if we have any witnesses or not. Like an
Yes, we do have one. We'll start the public testimony now.
Thank you.
And give you the right to close, Representative Cook. Chair calls M. Page Williams. Going once, twice. Ms. Williams was testifying for the Dallas County Criminal District Attorney John Crusoe. She was for the bill and will be shown as for the bill, but not testifying. Linda Borchardt does not appear to be present either. She will be shown as not testifying, but for the bill for the Tarrant County Criminal District Attorneys, Bill Sorrells. Chair calls Amy Bresnan, who is not wanting to testify. Do you mind if we change it to show that? Okay, all right. We will show it that way with the Texas Family Law Foundation. She was for the bill, but will be shown as not having testified. Chair calls Calvin Tillman. He doesn't appear to be present either. He was testifying for himself, but he was for House Bill 660 and would be shown as not testifying, but for the bill. Georgia Bates, testifying for Giffords and herself for the bill, but be shown that way, but not testifying. T.J. Patterson, the city of Fort Worth, he was testifying for the bill, but will be shown as not having testified. And that is it. Is there anyone else here who would like to testify on, for, or against House Bill 660? Chair hears none and recognizes the Honorable David Cook to close.
Member said, subject to any questions you may have, I'll close on this bill.
All right. The chair withdraws the committee substitute for House Bill 660 and leaves House Bill 660 pending as a matter of business before the full committee. Any objection? Chair hears none. So ordered. The chair at this time lays out House Bill 2067 and recognizes the author, Representative Cook, to explain the bill.
Thank you, Mr. Chairman. I appreciate the opportunity to lay out House Bill 2067. We do not have a committee substitute for this bill. Would ask for your favorable consideration with regard to House Bill 2067. This simply makes a change to Section 9.201 of the Texas Family Code by adding a new section to read as follows. Notwithstanding any other provision of this chapter, the court that rendered a final decree of divorce or annulment or another final order dividing property under this title retains continuing exclusive jurisdiction to render an order under this subchapter to divide property not divided, awarded to a spouse in a final decree. I attended a continuing education course over the interim and became aware of this problem, and really what it's probably only a problem in counties that have family law courts that are dedicated. Most counties probably have just general jurisdiction courts, and they hear civil cases, family cases, criminal cases. In Tarrant County or Harris County, where some of you are from, obviously here in Travis County, they have more specialty courts or just jurisdictions with regard to family law. And so there's been I guess a question as to whether or not these actions should be brought exclusively in the family code. And so it's, this bill is intended to give the court that divided the property or attempted to divide property, give them the opportunity to continue exclusive jurisdiction with regard to any property. Where you see this is if someone gets a divorce, they have a divorce decree, 6 months later, wife finds out that husband didn't disclose or there was no division of this piece of real property, then there's a dispute as to whether or not someone can go to the civil courts or should go back to the family courts. And this bill is intended to make it to where they would go back to the family court that would have exclusive jurisdiction.
All right. Any questions of Representative Cook, members? Not hearing any. We'll start the public testimony now.
Thank you, Mr. Chairman.
And give you the right to close. Chair calls Heather King.
In Your Honor, if I may, I'll say this lawyer here is very much more talented than I to explain the legal reasoning of this bill, but I do appreciate Ms. King testifying in our behalf.
Honored to do so. My name is Heather King. I'm here individually and as Vice President of the Texas Family Law Foundation, and I'm here to testify in favor of 2067. And I'll make this quick. I just want to point out that it's very logical and it makes perfect sense. If you look at the statute and go to the provision right before it, it specifically requires that the Texas Rules of Civil Procedure be applied to this scenario. So I think it makes sense to logically progress that the court that actually heard the property division, if they're still around, they actually heard the property division, they're familiar with the property division, they understand it, should be the one to hear any type of contested case. Additionally, I mean, this is a community property state that involves a disproportionate division, and sometimes there are facts and underlying facts that might support that as well. I want to point out that it's even possible that someone could be somewhere else on the other side of the world, and we really don't have anything in our code that I can find, and this is what Representative found out when he was looking at Representative Cook to really solve this problem. And so I think it's important that they go back to a family law court or a general jurisdiction court with experience in family law and experience in community property, and if at all possible, back to the court they were originally in order to have this heard. And so I support this bill for that reason, and I want to point out that because this has occurred to me, we might have a couple folks that actually agree that they need to do some type of agreed order to divide the marital estate. And so for those of you who are concerned about the ease of that, well, first I would point to Chair Dutton's 5291, which would allow these parties or particularly clarify that they can enter into an agreement and submit it in writing. And further, that any agreed order can be submitted in writing of this nature, of this type of lawsuit. So I think that it's an excellent idea to make sure that they go back to where they came from when they want to hear these cases heard. And I want to point out, I mean, there is no ability to waive jurisdiction. Once this happens, then this is not going to be a concern, because in our system under the Texas Supreme Court, when jurisdiction is established, you can't just go off and do your own thing. So I would testify in support of this bill. I think it's an excellent idea. I think it logically follows the former portion of the statute. And I welcome your questions.
Any questions for Ms. King, members? Not hearing any, Ms. King, thank you for being here. Thank you for your testimony.
Thank you, sir.
Is there
Is there anyone else here who would like to testify on, for, or against House Bill 2067? Not hearing any, Chair recognizes Representative Cook to close on the bill.
Thank you, Mr. Chairman. And the case, I did want to just for reference purposes, the legislative intent is not always important, but just from my perspective, the case that that was brought to our attention is SC versus MB individually and as next friend of JC respondent. And the case site is 650 Southwest 2nd 3, excuse me, shows my age, 650 Southwest 3rd, excuse me, 428 Supreme Court of Texas. And with that, members, I would offer myself for any questions. If not, I close.
All right. If there are no further questions, the chair's intent to leave House Bill 2067 as a matter of pending business before the full committee without objection. Chair hears none. And so ordered. The chair lays out at this time House Bill 1547 and asks the author, Representative Cook, to explain it. There is a committee substitute, and the chair at this time lays out the committee substitute for House Bill 1547 without objection. Chair hears none. And ask the chair at this time lays out House Bill 1547 and asks Representative Cook to explain the committee substitute.
Thank you, Mr. Chairman. Members, I know this is going to be a deep dive into marital property law, and probably especially at this hour, almost 5 o'clock today, I'm sure you're ready to go, but don't really need a law school lesson. Not that the chair would need that anyway, but I just want to give a big picture. We do have a resource witness here that's very well experienced on the issue and can give even more insight into why this is necessary. But just big picture, there's generally 3 marital estates when you look at a divorce. When somebody's coming forward and you're going to have a divorce situation, the court's going to look at the community estate, they're going to look at the separate estate of the husband, separate estate of the wife. So there's 3 estates, and sometimes one estate is receiving a benefit that if the court doesn't compensate for that benefit in some manner, then unjust enrichment will occur if the court does not require the benefited estate to be reimbursed by the conferring estate, simply meaning that if, let's say, if a spouse A has a substantial separate property estate, and she or he uses significant sums from the separate estate in order to benefit the community estate, then this reimbursement process is intended to give her separate estate the opportunity to be reimbursed appropriately based upon the benefit that's been conferred upon community estate. So currently, Texas Family Code Section 3.402 does not mention the 3 traditional elements, and due to its extremely narrow focus, the statute can be confusing and is often misinterpreted. Additionally, it fails to explain how different types of benefits should be valued. Not all claims are valued in the same manner, and the date as of which the benefit should be valued, when the benefit was conferred, the date of the trial, or some other date. The term that we hear often, and I expect Ms. Bradshaw may talk about, is the date of inception, or the inception rule that we all look at, and that's what this is referring to. But 3.402A often uses the term estate as if it means an entity which owns property or incurs debt and liabilities, instead of meaning either the marital estate or the separate estate of either party, i.e. the property owned, not an entity which owns property. To be clear, estates are not entities. They do not own property, nor do they owe debts or liabilities. Instead, people own property and they owe debts or liabilities. Further, read in isolation, there is an argument that Section 3.402A5 makes all principal reduction reimbursable even if the payment did not benefit another estate upon a benefit upon the other estate, but instead to the paying estate. Thus, it's necessary to amend and clarify the reimbursement section to add definitions of specific terms to provide direction to courts and practitioners and add clarifications, et cetera. So specifically, members, what committee substitute for House Bill 1547 does is a cleanup, and it adds a phrase that simply puts the respective provisions even more in line with Jensen and Valone, two very well-known cases in this area of law. There was some ambiguity in the first version that came back from Legislative Council, and therefore, in an attempt to make it more clear with regard to the intent, the committee substitute is offered. The committee substitute does clarify that a just and right division does not apply in probate. And the committee substitute also strikes those words from a provision in the previously filed version. The most important thing we do as family lawyers and as legislators today is to help men, women, mothers, and fathers move on with their lives without losing what is rightfully theirs when going through a difficult time, also known as a divorce. This bill is a win for parents and win for husbands and wives in fairly dividing their properties and moving on into their parents who successfully co-parent going forward. That should always be the goal of the legislature. Anytime we can have parents that are going through a divorce go through a more harmonious process, we're going to be better off. And I often tell clients that, we may be divorcing you as husband and wife, but you're going to continue to be mother and father, mom and dad, et cetera. And so therefore, the more that we can work together in order to make it a seamless process, the better. And I believe that the committee substitute for House Bill 1547 does give clarification that will be useful to practitioners and families of Texas. And I would make myself available for any questions, and otherwise would like the opportunity to close when appropriate, Mr. Chairman.
All right. Any questions of Representative Cook, members? Not hearing any. We'll start the public testimony at this point and give you the right to close, Mr. Cook. The chair calls Charlotte Bradshaw.
Thank you, committee. My name is Charlotte Bradshaw. I'm going on 30 years practicing family law out of Denton, Texas. I'm here for the Texas Family Law Foundation and myself, and we are for the bill. Absolutely. We have wanted this statute, this group of statutes redone for years. I will start off I agree with everything David said. One of the things that happens is you have, like he said, you have a separate estate of husband, a separate estate of wife, and a community estate. And when these states start paying for things for each other or improving property that belongs to the other one, paying a debt, or time, toil, and talent, which is the case law, because time, toil, and talent is community property. And so that belongs to the community. And so the statute has caused great concern on advising clients, one, because it's so convoluted the way it's currently written and needs to be revamped to just exactly what David said. The other thing, it's very difficult to settle these cases when somebody has put hundreds of thousands of dollars or money into the other person's estate that they're going to walk off with. And so that's really the nemesis of the statute. But it does cause confusion, and it stops us in mediation. One of the things it does is that the measure of the claim has been a big problem. What is the number? And so now we're clear on the number that if it's a debt, liability, or expense, it's what was paid. If you improve real property, it's what is the increase in the value, not the dollars that were paid, but the increase in the value. And because these rules, all of these statutes are used in probate court, the committee substitute makes it clear that it's not just at the time of divorce, but it would be at the time the first spouse dies. So these really need to be cleaned up for the probate courts as well, because they're following these exact rules. And then the value of the time, toil, and talent would be you're spending your time, toil, and talent that belongs to the community on your own separate estate. And so in order to manage it, preserve it, and just keep it as it is, that's one thing. But when you go improving it using the time, toil, and talent of the community, that's going to create a claim, and it would be the measure of the labor that was done to not just manage and preserve. It's based on unjust enrichment. David is right. Representative Cook, sorry, I've known him so long. But the court will decide if it's unjust enrichment. Was this fair? The good thing, too, and we've had this in the case law, is that a court can also, if there's different reimbursement claims in the case, we can offset them. They're not a property right. They're a claim of equity. So these claims can be offset with each other. Husband's got one, wife's got another, spouse got another. So they can offset them. And some of those are laid out in the family code. The important thing to know too is that, common law, we still have reimbursement claims out there that are not in the statute. So this statute is not mutually exclusive of the only claims that can be brought. So I'm happy to answer any questions.
Okay, any questions of Ms. Bradshaw, members? Not hearing any, Ms. Bradshaw, thank you.
Thank you.
For being here, thank you for your patience. Is there anyone else here who would like to testify for, on, or against House Bill 1547? Not hearing any, the chair recognizes Representative Cook to close.
Thank you, Mr. Chairman. Members, I'll make myself available for any further questions. I think Ms. Bradshaw did an excellent job of going through the bill, and I would like to make any clarifications if you have any that I need to make. Otherwise, I'll close.
All right, thank you. It's the chair's intent to withdraw the committee substitute for House Bill 1547 and leave House Bill 1547 as a matter of pending business before the committee without objection. Chair hears none. So ordered. The chair at this time lays out House Bill 2070 and recognizes Representative Cook to explain it.
Thank you, Mr. Chairman. Members, House Bill 2070 does not have a substitute either, so we'll be looking just at the originally filed bill. If you look at it, appears to be a very simple change. It adds the words, the procedural requirements for, and you might ask, what does that mean, and why are we taking time to do this? And so I just want to give you the background. There was an attorney that had a case where opposing counsel was arguing that a lesser procedure or burden was required to just do a motion to continue the spousal support for a motion to modify. And the current statute, you see there in Chapter 8 of the Texas Family Code, does give opportunities to modify spousal maintenance. But it's called a motion to continue, and the text does not say it is subject to rules applicable to the filing of a new lawsuit. So this is a due process issue where it's necessary that the respondent does receive notice, adequate notice, and an opportunity to defend, and the respondent be deprived of his or her separate property. One former spouse has no legal duty to provide support to the other former spouse unless that duty is properly imposed under the auspice of Chapter 8. So Chapter 8 is the only opportunity you hear of alimony or things like that. In Texas, it's known as spousal maintenance. It's found within Chapter 8. And so as far as a continuing measure of support post-divorce, Chapter 8 is the opportunity to do so, allowing the court to require one former spouse to take his separate property income and give it to the other former spouse without allowing adequate notice and opportunity to defend would be defending the first spouse of his or her separate property without due process of law. So this is a very simple change to a problem that does come up fairly often with regard to spousal maintenance issues, and I would be glad to answer any questions from any member. Otherwise, I'd like an opportunity to close, Mr. Chairman, when appropriate.
Any questions of Representative Cook, members? Not hearing any, thank you. Representative Cook. We'll start the public testimony. Chair calls Charlotte Bradshaw.
My name is Charlotte Bradshaw. I've practiced almost 30 years, board certified in family law, and I'm here on behalf of myself and the Texas Family Law Foundation. So as far as maintenance can be ordered in two different ways when there is disability involved. One is if the parent has a child and they're going to have custody of the child and it's going to require personal supervision to actually care for the child to keep them from getting suitable employment to meet their minimum reasonable needs, which is the test, or they themselves, because of a physical or mental incapacitating disability, can't make suitable employment for minimum reasonable needs. So those are the two things that Representative Cook's bill is addressing. The Family Code says that spousal maintenance can be paid for so long as these conditions exist. So if somebody feels that the payor feels it doesn't exist anymore, they can file to terminate it, okay? Well, the statute says for the procedure to continue it or change it in these two respects, you've got to jump over to the motion to modify section of the Texas Family Code. And that's what Representative Cook is referring to is the modification versus the continuation. And so they're not seeing, like some lawyers are seeing, well, I can just, I don't have to give you due process. I mean, it just continues because it's still here. And so this bill is making clear that the procedural requirements over in the motion to modify section apply because the code says the rest of that section applies anyway. So it's to resound that you have to follow the rules of procedure if you're going to contest this.
Any questions of Ms. Bradshaw, member? I'm not hearing any, Ms. Bradshaw. Thank you for being here.
Thank you.
Is there anyone else here who would like to testify for, on, or against House Bill 2070? Not hearing any, the chair recognizes Representative Cook to close.
Thank you, Mr. Chairman. Members, again, I'm always available for questions, but otherwise, if there are none, I close.
Okay, thank you. It's the chair's intent, without objection, to leave House Bill 2070 as a matter of pending business before the full committee. That's right. The chair calls up House Bill 3754 and recognizes its author, Representative Tallarico.
Thank you, Mr. Chairman and committee members, for the opportunity to lay out House Bill 3754. Texas is one of just 4 states where courts can stop spouses from getting a divorce solely because the wife is pregnant. While there's nothing in Texas law that explicitly forbids a court from granting a divorce in these situations, courts almost always delay or deny a divorce suit until a child is born. Delaying a divorce determination solely because one party is pregnant creates a costly, undue burden on everyone involved, both emotionally and financially. And in cases of domestic violence, it can be deadly. Forcing a victim of abuse to stay married to their abuser simply because she's pregnant can cost her life. HB 3754 explicitly prohibits a court from denying or delaying a divorce suit solely because a party to the suit is pregnant. This will help speed up the oftentimes painful divorce process for both spouses. I also want to let y'all know we're working with stakeholders on some changes to the bill that we'll put in a committee sub and submit to the committee. I'll tell you the 2 changes. One, as filed, the bill says that the petition for divorce must disclose whether one party to the suit is pregnant. We'd like to remove that requirement because there are many instances where the wife may not know she is pregnant at the time of filing. That's why current law doesn't mandate this in divorce filings. We don't want to change that. And then the second change to the bill is, as filed, the bill says the court shall defer adjudicating issues related to the suit affecting the parent-child relationship until the child is born. We'd like to change this to give courts more discretion so that spouses can start these conversations as soon as they'd like to. At this time, I'd be happy to answer any questions, and I'd like to reserve my right to close.
Any questions of Mr. Tallarico, members? Not hearing any. We will start the public testimony. The chair calls Ms. Heather King.
Hello, my name is Heather King. I am a board-certified family attorney since the year 2000, practiced since 1995. I'm the current vice president of the Texas Family Law Foundation. I'm here individually and on behalf of the foundation to testify in favor of 3754. I want to thank Ms. Gina Hinojosa. We have had many great conversations over the last couple of days, including this morning, as well as very late last night. We have worked closely together in an effort to put something together which I know is still in the works. I want to testify that, I think it's extremely important to allow certain married couples the opportunity to get divorced even if the wife is pregnant. Of course, the courts will have discretion when they want to get involved, but it's very important to understand exactly what this says is that if the sole reason is the pregnancy, then they cannot use that as the sole reason. And I think there's a lot of things that people don't give consideration to that I see as a family law attorney every day. Okay, first, the family law courts retain the right to adjudicate paternity. They retain the right to handle suits affecting the parent-child relationship, which we often call SAPSers, regardless of marital status. It does not take away the woman's right to get a SAPSer, a judge, to get child support, to seek conservatorship arrangements, or a man for that matter. And so this doesn't change anything except it gives married people who find out that a child is coming during their marriage the opportunity to still get divorced. Okay? As I've heard, many times today, as well as when I've spoken to various legislators, the community estate continues to grow, and it grows until the day that divorce is granted. And the money put into that 401k grows until the day the divorce is granted, and the monies received for bonuses grows until the divorce is granted. What if we have a pregnant wife who they've already agreed to get divorced? What if it's not his child? Many people, because it takes 2 or 3 years to get divorced in the larger counties, okay, begin to date by agreement. They begin to date other people by agreement, okay? A child is conceived, the wife wants to keep that child, yet she is forced to remain married, for her 401k to continue to grow and be community property. And the same can be true of the man, okay? If he's aware that this child is not his, okay, and everyone agrees this child is not his, and the real father has stepped, or the biological father has stepped forward, why should he be forced to continue to contribute to the community estate so that there are financial issues for him when both of them acknowledge the situation? Okay? And so I think it's important for us to think of this not just in terms of whether a child is born to a couple who are married, okay? But rather, nothing has changed. The opportunity for a suit affecting parent-child relationship remains intact. The opportunity to make sure the best interest of the child is watched after remains intact, okay? And so we are here in support of this bill for the reason that married couples who are getting divorced under the correct circumstances should be given the opportunity to get divorced regardless of whether a pregnancy exists. And the court should not merely deny them that just because someone is pregnant. And I welcome any questions.
All right. Any questions of Ms. King, members?
Very nice.
I think Representative Cook has a question.
I guess my question is in your position, does it matter if the child the unborn child is expected to be of the marriage or not of the marriage?
That's an excellent question, and I honestly, in light of the law in its current state and the ability to continue to have a SAPSR regardless, I don't see that it matters, but I do understand that it might matter to particular judges.
Right.
And this is why the statute will give those judges the opportunity to give that consideration, because I think you and I both know as family law practitioners from the same place that if a judge feels like they need to require the marriage to continue, they're going to find a reason to require the marriage to continue so that their sole reason is not the fact that a pregnancy exists. And I think the entire purpose behind the statute as it was originally played out is from a very long time ago. And the point was to allow the court to have the opportunity to award child support. And I think we both tell our clients, this is why the court does this, because nobody knows what's going to happen. What is going to happen with this child? Now we're able to determine before birth often what the DNA results are and who the father is, if you want to. That's the choice of the people. But as the law sets now, we have modernized, okay? The men and women have the opportunity to continue to come back to court and get a suit affecting parent-child relationship and aren't required to remain married for the sole reason that a woman is pregnant. I'm not making light of the child. I mean, I was born of a single parent, okay? I'm not making light of that. What I'm saying is that it's not necessary to force people to stay married during a pregnancy. The court may find a good reason to do it, okay? But it's not necessary to force it just for that reason. And I'm sorry I went on and on.
No, I appreciate your expertise and experience, which you certainly have. And I guess the only other question I always regret when I say that, but one other question that I have is, how do you think judges will feel about this? I mean, like from the foundation's perspective, have y'all had any conversations and what their thoughts are?
I'll admit to you, this has come on very fast. And so it would be disingenuous of me to tell you that I've had an opportunity to speak to many different judges. I will tell you, Representative Cook, that I am glad to do so. And if you wish that I do so, I am glad to poll the judges to get opinions in Tarrant County and various counties and provide that information if that's appropriate to do. I would say that I think it's going to be mixed. I think you and I both know it's going to be mixed. I'm trying not to look at this from any other perspective than the perspective of forcing people to remain married when neither of them want to, in particular. When neither of them want to, when they both acknowledge a situation. And so, but I'm if the representative wants me to do so, I'm glad to do so and let you know what I find.
Sure. I mean, I think it would be helpful, maybe to the author as well. And then just procedurally, do you think this is almost like an abatement? Is that how you see this playing out, or what do you?
Boy, now you're
I mean,
gonna ask me a hard.
well, I guess we don't have to get legally, we don't have to get into like legal terms, but I just meant like, do you expect that the case will be maintained on the active docket, but no action being taken?
That's one way to do it. That's not how my brain was thinking of it, but now you have planted that seed. And so I can see that that's one way to do it. Another way to do it, of course, is to just come back for the SAPSR as an original SAPSR or a separate lawsuit, depending on many things, depending on parentage and things like that. So yes, procedure has to be considered and worked out.
Yeah, I would want that to be part of the bill. And for me to feel comfortable in supporting the bill, I would think that needs to be flushed out because of the question.
SAPSR eats the divorce, divorce eats the SAPSR. I know exactly what you're talking about.
Yeah.
I'm not even going to try and go there with y'all. And Mr. Representative, I'm glad to work with you on that. In the future, whether I'm here, I would like to keep working and work out some procedure that will be acceptable to Representative Cook.
Well, just in general, I think the policy is is good. I mean, I've certainly had situations where I think this would be very helpful, but I guess the hang up that I have is not knowing whether the child is of the marriage or not of the marriage. And if the child is of the marriage, I think it should it would be much easier, much cheaper for the parties for the case just to be quote unquote abated or something of that sort, and not have to file a new lawsuit. Go try to track down and get service on if dad is no longer in the picture or whatever the case is. It just seems like you already have service, you've already started a lawsuit, you've already paid a filing fee, and right now you get both. For your $350 filing fee, you get a divorce and you get a SAPSR all included in your order. But just something to think about. I think that whether or not it's pending, continues to pend, would be of importance, because if it is a situation where it's the child not of the marriage, then you probably need to bring in that person that that is going to be adjudicated to be the father into the same suit. But just a thought.
So, may I ask you a question?
Of course.
Were you thinking in terms of perhaps abatement in the context of if it is biologically proven to be the child of the married couple versus perhaps a different procedure otherwise?
Well, I mean, I guess what I was saying, abatement, let's kind of back up. So how I think way the author, would intend for this to be is, I guess whether it's by trial or, let's probably more realistically, it's going to be where, you and I have a case, our parties agree, we want to get our property division done. We take a decree to the court and it says, Judge, we want you to sign this final decree of divorce. It does not include a SAPSR. We want to sever, for lack of a better term, we want to sever the SAPSR, and make it a separate cause. I mean, that's kind of, so that's what I was thinking. And so that it's, you're not having to start back over, you go back through discovery process necessarily and, all that kind of stuff.
So many things. So I understand, and I if you're willing, I think we can work on this.
Yeah. Let me ask you a question here, though.
Yes, sir.
Do we not have divorces now where couples get divorced and then have a property settlement later?
No, sir.
We don't do that?
No, once the property settlement is made in the divorce, except for property that is not divided, it is final.
So I don't mean that. I don't mean.
Oh, I'm sorry,
final.
I misunderstood.
I'm not asking whether it's final. I'm asking whether you could have one procedure follow the other one. Whether you could have a dissolution for the property, or at least a judgment on the property disposition in the marriage that comes after the divorce.
So it's kind of strange. You can sever the SAPSR, okay, and the suit affecting the parent-child relationship. I apologize, I'm so used to using the acronym. Yeah. You can sever the suit affecting the parent-child relationship, but you can't get a divorce without joining the SAPSR. So you can throw the SAPSR, but you can't throw the divorce. Did I say that right, Representative Cook?
Right.
So we'd obviously have to deal with this situation to make sure that if the bill passes, there's a method by which it can be done without any hinges. But no, you can't divorce without the SAPSR, but you can SAPSR without the divorce.
Well, that's not what I'm asking, though.
Okay, I am so sorry. I'm trying to
That's
do
not what
this
I'm
right.
asking. In a divorce, there's community property and separate property, right?
Correct.
Okay. Could you get divorced and then resolve the issues related to community property and separate property later?
No.
You can't
In
do
my
that?
in my opinion, you cannot.
I don't see that either.
So in my opinion, the only way to stop the growth of the community estate is either to agree that it stops or to get the divorce granted.
But in no case could you ever have the situation where the court made a determination about either after the divorce. After the divorce is declared, well, I guess it wouldn't be final until the property settlement was done, but where the two parties were actually divorced.
In my opinion, I do not believe if the two parties are actually divorced, there is ability to divide any more property. And I welcome the family law attorneys on this panel to correct me.
Okay.
But that is my understanding.
That question came to me, and I don't, and the way it was presented was, is there anything in the law that prevents it? And I couldn't figure out where that would be.
I'll give it my best shot to think I have a general idea of maybe where it comes from. Okay, and I believe it comes from the concept that a division of property in a decree is full and final and is not modifiable under any circumstances. And so I believe that's where that comes from. I'm guessing.
Okay, well, anyway, it's, because I was thinking that if it could be done, then it could be done on the side of the SAPSR also.
Presently, to the best of my knowledge, it cannot be done.
Okay.
I hope I'm not misspeaking,
All right.
but that's my
Well,
understanding.
Everybody that I spoke to said that, except one person said, no, there's nothing in the law that prohibits a settlement of property to follow a divorce.
I don't
I think it's,
don't know how you make a just and right division with.
No, yeah, I mean, the just and right division is based upon the character of the estate, which is accomplished and concluded at the divorce time, and I think that's what creates the problem.
Right, but I think what they were saying was that on the date of the divorce, that would be the termination of any changes into the property. And so when it came to dividing it, it would be a division that would surround that date.
So my opinion is that because the division has to be just and right based upon the facts and circumstances at that time, that the division has to occur at that time.
On the date of divorce.
Yes.
That you have to do it on that date.
But it's
You couldn't
valued.
just calculate it, value it on that date. And that's what the argument was.
No, I mean, a couple who wants to agree to stuff can agree to stuff. But if they're not, I don't see any way that it can continue past the date of divorce, my opinion.
Okay, all right. Okay.
I think in practice, what you would see, Mr. Chairman, is, and you probably have had this situation, is you would see an aid or something, like which is a binding contract, and so you would make an agreement and say, okay, this is going to be the property settlement, but it's not going to be presented until such time as a divorce is granted.
And
so that would be a contractual way to do it, keep it out of
And you couldn't do it so that it became effective after the divorce.
I don't believe so either.
I think people can agree to certain stuff happening after the divorce. Like if a bonus comes in March and the divorce happened in December, but the bonus is for work done during the prior year, then you can see property still being distributed, but it's still based on that date of divorce.
Right. And that's really what I was saying about the property division too, because the date of divorce would be the date of the value of the estate.
Unless otherwise agreed, yes, sir.
Right, and then the distribution of it, or the resolution of it in terms of who owns what and who gets what, couldn't come after the divorce.
That's correct, except I will say sometimes the distribution is going to happen after the divorce
Right,
because
yeah,
the
always-
property
most
doesn't
generally.
come into play until after the divorce. But the actual decision and finalization occurs on the date of divorce, unless people agree, and people can agree the moon is made of cheese.
All right. All right, any further questions? I think Representative Talarico.
Sure, no, I'm
It's his bill.
not a family law attorney, so I'm not going to get in the middle of that discussion. But to our bill, 46 other states have figured out a way to resolve divorce suits separately from parent-child relationship suits, correct?
That's correct.
Okay.
Arizona, Missouri, and Arkansas and Texas are the four that remain.
Okay, so this works in 46 other states doing
That's
it.
correct.
Okay. That's great, and I appreciate you being here. Also, just want to clarify for the record, when you talked about working with Gina Hinojosa, you're talking about our chief of staff, not the representative
Oh,
Gina
I'm sorry.
Hinojosa. Although I'm sure she would support this bill. I just don't want to bring the representative into
That
our
was
bill.
not intentional.
No, that's okay.
Apologize for that.
That's okay. Thank you for
Well, we
being
thought she was just throwing around names.
just name dropping other reps. Thank you.
Thank you.
Any further questions of this witness
Sorry.
member? No further questions. Thank you, Ms. King. Thank you. Is there anyone else here who would like to testify on, for, or against House Bill 3754? Not hearing any, Chair recognizes Representative Talarico to close.
Thank you, Chairman Dutton. Thank you, committee members. And like I said, we are working on a few changes, and so if there are other possible tweaks to the bill, would be happy to discuss it and include it in the sub before we vote. But I do think most of the states have done this. You shouldn't just be able to deny a divorce just because someone's pregnant. That's a pretty common sense thing. But happy to work on details. So
thank you.
Thank you. And if there are no other questions, I close.
Thank you for the bill. It's the chair's intent to leave House Bill 3754 as a matter pending business before the full committee. Without objection, the chair hears none. So ordered. Members, that includes today's agenda. We have several bills on pending business I'd like to take up at this point, so that we can sort of get, we're about, I think we have only 63 days left in this session. So it's relatively moving pretty fast. And from now on, it'll be moving extremely fast. And so with that, members, Chair at this time lays out House Bill 77. Members, this was a bill by Chairwoman Criado, which removed runaway as a status offense and directed, tried to direct the Department of Protective and Family Services to aid in this. Is there any objection to hearing House Bill 77? Chair hears none. Representative Talarico moves that House Bill 77 be reported to the full House with a recommendation. That's Criado's status, removing runaway as a status offense.
I think I'm a no on that.
Okay. All right. Okay. All right. Representative Talarico moves that House Bill 77 be reported to full House with recommendation do pass and be printed. Clerk will call the roll.
Vice Chair Lujan?
Support, yes. Me.
Did you say that?
Yes,
Oh,
I'm sorry. I'm sorry.
Representative Cook?
Yes.
Representative Leo Wilson?
Yes.
Representative Lopez? Representative Martinez Fisher? Representative Smithy?
No.
Representative Talarico?
Aye.
Representative Wu?
Aye.
Chair Dutton?
Aye.
7-1.
There being 7 ayes and 1 nay, House Bill 77 passes to the full House. Chair at this time lays out House Bill 250 as a matter of pending business. This bill members allows injured victims of any crime in their family and household members to apply for relocation benefits while preserving the direction of the Office of Attorney General. It also ensures that household members or family members who need mental health care or bereavement time as a result of the care can get it from this program. The chair offers up the committee substitute to House Bill 250 without objection. This made a technical change to clarify that the maximum number of claims for relocation assistance can be made in a given victimization and clarifies guidelines around the caps on bereavement loss of income coverage. Any objection to adoption of the committee substitute? Chair hears none. The substitute is adopted. Representative Wu moves that House Bill 250 as substituted be reported to the full House for recommendation to do pass and be printed. Clerk will call the roll.
Vice Chair Lujan. Representative Cook.
Aye.
Representative Leo Wilson.
Yes.
Representative Lopez. Representative Martinez Fisher. Representative Smithy. Representative Talarico. Representative Wu. Chair Dutton.
Aye. 8 ayes and no nays. The motion prevails. Chair at this time lays out House Bill 422 by Chairman Van Dever members as a matter of pending business. This reduces the time that juveniles spend in detention facilities by granting judges the authority to conduct virtual remote hearings. The chair at this time offers up the committee substitute to House Bill 422, which removed any mention of virtual proceedings for jury trials, so that jury trials are not affected by the remote idea. Members, any objection to adoption of the committee substitute? The chair hears none. Substitute is adopted. Representative Cook moves that House Bill 422 as substituted be reported to the full House for the recommendation to do pass and be printed. Clerk will call the roll.
Vice Chair Lujan.
Aye.
Representative Cook.
Aye.
Representative Leo Wilson.
Yes.
Representative Lopez. Representative Martinez Fisher.
Oh, chair recognizes Representative Martinez Fisher's back.
Representative Martinez Fisher.
Yes.
Representative Smithy. Representative Talarico.
Aye.
Representative Wu.
Aye.
Chair Dutton.
Aye.
9.
There are 9 ayes and no nays. House Bill 422 passes to the full House. The motion prevails. House Bill 474, the chair lays out House Bill 474 by Representative Hall members. As a matter of pending business, this adds and defines the terms to differentiate active versus inactive trained volunteers. This bill also will require each individual court-appointed advocate program to have a grievance procedure for the individual being served. Is there any objection to hearing House Bill 474? Chair hears none. Representative Leo Wilson moves that House Bill 474 be reported to the full House for the recommendation do pass and be printed and sent to the local and consent calendar, members. Any objection? Clerk will call the roll.
Vice Chair Lujan.
Aye.
Representative Cook.
Aye.
Representative Leo Wilson.
Yes.
Representative Lopez. Representative Martinez Fisher.
Yes.
Representative Smithy. Representative Talarico.
Aye.
Representative Wu.
Aye.
Chair Dutton.
Aye.
9.
9 ayes and no nays. House Bill 474. The motion passes to get House Bill 474 to the full House.
No, local
To the committee, to local and consent, I'm sorry. Chair at this time lays out House Bill 458 by Speaker Tom Craddock. Members, this is a matter of pending business that required the TJJD to accept custody of a person sentenced to commitment within 30 days of the judge signing the disposition. The chair offers up the committee substitute to House Bill 458 without objection. This is the committee substitute members provides compensation to counties for children not picked up by the 31st day of the counties from TJJD and provides a child credit for time served between beginning the 31st day if TJJD does not accept them, it also removes Section 2, which required the application to anyone sentenced after the effective date. As TJJD indicated, they would just about never pick those children up. Any objection to adoption of the committee substitute? Chair hears none. The substitute is adopted. Representative Smithy moves that House Bill 458 is substituted be reported to the full House with a recommendation to pass to be printed. Clerk will call the roll.
Vice Chair Lujan?
Aye.
Representative Cook?
Aye.
Representative Leo Wilson? Representative Lopez? Representative Martinez Fisher?
Yes.
Representative Smithy? Representative Talarico? Representative Wu?
Aye.
Chair Dutton?
Aye.
8-1.
There being 8 ayes and 1 nay, House Bill, the motion prevails for House Bill 458. Chair at this time lays out House Bill 956. Members, this was a bill by me, by M.E., which is clarified and established that expert testimony is not necessary to determine if it is in the best interest of the child for a grandparent to have access to the child. House Bill 956 would also eliminate the unneeded categories so that all biological and adoptive parents may file the access suit, but still must demonstrate the significant impairment element, members. This is a bill we passed in this committee before, as I recall. And what we were trying to do is make sure that there is no impediments to grandparents, many of whom are raising some of these children, to them making application and trying to establish that it's in the best interest of the child for the grandparent to have simple access to the child. In the way the law works now is there was an expert testimony required so that these grandparents might be determined to have access. Any objection to hearing this Bill 956, members? Not hearing any. Mr. Talarico moves that House Bill 956 be reported to the full House with a recommendation that it do pass and be printed. Clerk will call the roll.
Vice Chair Lujan?
Aye.
Representative Cook?
Respectfully, no.
Oh, man. Representative Leo Wilson? Oh, man. Representative Lopez? Representative Martinez Fisher?
Yes, twice.
Representative Smithy? Representative Talarico?
Aye.
Representative Wu?
Aye.
Chair Dutton?
Aye.
7-2.
There being 7 ayes and no nays, House Bill
No,
956.
7-2.
That's what I said, 7-2.
No, you said 7-0. You said 7-9.
No, I said 7-2.
Okay.
And I'll say it again. There being 7 ayes and 2 nays, the motion prevails. Chair lays out House Bill 1429 by Representative Campos, members. This is a matter of pending business, which this bill removed the requirement that a household member be related to the victim by consanguinity or affinity. This would allow for individuals such as fiancés, roommates, and domestic partners to have clear access to the compensation from the Crime Victims Compensation Fund. Any objection to hearing this bill? Chair hears none. Representative Cook moves that House Bill 1429 be reported to full House with recommendation to pass and be printed. Clerk will call the roll.
Vice Chair Lujan?
Aye.
Representative Cook?
Aye.
Representative Leo Wilson? No. Representative Lopez? Representative Martinez Fisher?
Yes.
Representative Smithy? Representative Talarico? Representative Wu?
Aye.
Chair Dutton?
Aye.
8-1.
There being 8 ayes and 1 nay, the motion prevails. Members, Chair lays out at this time House Bill 1502 by Representative Placer. This is a matter of pending business which requires each attorney employed or contracted by the Department of Family and Protective Services involved in cases seeking termination of the parent-child relationship or appointment of conservatorship to complete a trauma-informed care training. The training must include instruction on the child's development, emotions, memories, decision-making, and behavior, how these functions are impacted by the child's personal experience. The training shall also include the appropriate potential for re-traumatization, as well as availability of services and interventions. Any members, any objection to hearing this bill? Not hearing any. Chair Lujan, Vice Chair Lujan moves that House Bill 1502 be reported to the full House with a recommendation do pass and be printed. Clerk will call the roll.
Vice Chair Lujan.
Aye.
Representative Cook.
Aye.
Representative Leo Wilson. No. Representative Lopez. Representative Martinez Fisher.
Yes.
Representative Smithy.
Aye.
Representative Tallarico.
Aye.
Representative Wu.
Aye.
Chair Dutton.
Aye.
8-1.
8 ayes and no nays. The motion.
8-1.
8 ayes and 1 nay. The motion prevails. Chair at this time lays out House Bill 1654 by Representative Cook. Members, this is a matter of pending business which gives the state a better option to seek a determinate sentence when a juvenile gang member engages in organized criminal activity involving a violent criminal offense. With a determinate sentence, the juvenile offender can receive the benefits of extended and essential rehabilitative services with an incentive to fully participate in such services to avoid being transferred to the adult criminal justice system. Any objection to hearing House Bill 1654 by Representative Cook? Chair hears none. Representative Cook moves that House Bill 1654 be reported to the full House with a recommendation do pass and be printed. The clerk will call the roll.
Vice Chair Lujan.
Aye.
Representative Cook.
Aye.
Representative Leo Wilson.
Yes.
Representative Lopez. Representative Martinez Fisher.
No.
Representative Smithy.
Aye.
Representative Tallarico.
Respectfully, no.
Representative Wu. Okay.
Present. Tallarico.
Chair
Read the
Dutton.
bill.
Aye.
No, I'll vote aye. Sorry. Aye.
Show Representative Wu as aye on House Bill 1654, not B and B.
7-2.
There being 7 ayes and 2 nays, the motion prevails. Chair lays out House Bill 2037 by Representative Ann Johnson. Members, this is a matter of pending business. This updated and adds to Chapter 55 of the Texas Family Code relating to the proceedings in juvenile court for children with mental illness and intellectual disabilities. Additionally, House Bill 2037 revises the Family Code related to the mental examination of a juvenile. Members, any objection to hearing House Bill 2037? Chair hears none. Representative Dutton moves that House Bill 2037 be reported to the full House with a recommendation to do pass and be printed. Clerk will call the roll.
Vice Chair Lujan.
Aye.
Representative Cook.
Aye.
Representative Leo Wilson.
Yes.
Representative Lopez. Representative Martinez Fisher.
Yes.
Representative Smithy.
Aye.
Representative Tallarico.
Aye.
Representative Wu.
Aye.
Chair Dutton.
Aye.
9.
There being 9 ayes and 0 nays, the motion prevails. Okay, Chair at this time lays out House Bill 2268, members by Chairman Dutton. This is a bill that's a matter of pending business and allows the district court, when necessary, to refer to an associate judge an application for a protective order, an application for a writ, as well as petitions for temporary authorizations. Any objection to hearing House Bill 2268? Chair hears none. Representative Dutton moves that House Bill 2268 be reported to the full House with a recommendation to do pass, be printed, and sent to the local and consent calendar. Clerk will call the roll.
Vice Chair Lujan.
Aye.
Representative Cook.
Aye.
Representative Leo Wilson.
Yes.
Representative Lopez. Representative Martinez Fisher.
Yes.
Representative Smithy.
Aye.
Representative Tallarico.
Aye.
Representative Wu.
Aye.
Chair Dutton.
Aye.
9.
9 ayes and 0 nays. House Bill 2268 Passes to the full House. Chair at this time lays out House Bill 2794 by Representative Lujan members. This is a bill which allows the CASA programs to use state funding to serve on court-ordered service cases. This prevents, however, CASA from providing critical support to children and families who need help remaining safely together outside the foster care system. Any objection to adoption and any objection to hearing House Bill 2794 by Vice Chair Lujan? Chair hears none. Representative Lujan moves that House Bill 2794 be reported to the full House with a recommendation to do pass and be printed and sent to the general calendar. Clerk will call the roll.
Vice Chair Lujan.
Aye.
Representative Cook.
Aye.
Representative Leo Wilson.
Yes.
Representative Lopez. Representative Martinez Fisher.
Yes.
Representative Smithy.
Aye.
Representative Talarico.
Aye.
Representative Wu.
Aye.
Are you sure? Chair Dutton.
Aye. 9 ayes and 0 nays. The motion prevails. And lastly, members,
Yeah, just, that does say local.
Yeah.
Alternative education placement. I think there's confusion.
no, we didn't go to local. I didn't.
That means we can harass someone's wife more.
I didn't, so. Chair at this time, members, lays out House Bill 2946.
Mr. Chair.
No, he
Yes.
wants to keep it down.
Oh, okay. Oh, he does, okay.
Yeah. 20, Chair at this time lays out House Bill 2946 by Chairman Ken King, members. I know there's been some question about this bill, but this bill, what it does is it requires JJEPs to provide 43,200 minutes of instructional time a year. And what it does is it aligns it with the requirements of traditional public schools. For some reason, we had a situation where some of the JJPs were not actually conforming to the time requirements of traditional public schools, and this just aligns them with that, so they're all the same. And I went to talk to him about it just to be sure that that's what he's doing. Anyway, there is a committee substitute. The chair at this time offers up the committee substitute. House Bill. Okay, sure. Let me lay out the substitute first, which is just a legislative council draft of the original bill. And are there questions? Yes, sir.
Yeah.
Chair recognizes Representative Talarico.
Thank you, Mr. Chairman. I don't want to mess with Chairman King's bill, but I just want to, because I'm unclear, because the way I'm reading the bill, it takes out 7 hours per day for 180 days. That would be 75,600 minutes, which is what TEA requires, what we currently require. And he's replacing it with 43,200 minutes. So, because I don't want to, if it doesn't lower the amount of instructional minutes, I want to vote for it.
No, what it does is it aligns it with the alternative education requirement, time requirement, not the requirements of a traditional public classroom.
Got it. So it is lowering the amount of instructional minutes from what's currently in statute for
Not for alternative though, but for traditional public campus or public schools it is. It would be different, but it aligns it with the requirements that we have in alternative campuses.
the current case is 75,000 for juvenile justice alternative education programs. Just if I'm looking at the statute, he's deleting. I understand what you're saying, though, Chairman. I just want to, yeah.
Yeah, and so if there's a question, we'll just hold it. We'll just hold it because there's no, and we'll get Chairman King
Better be safe.
to talk to us. Okay.
Okay.
All right.
I don't want to.
Because I don't want you to feel. I don't want any member ever to feel uncomfortable with one of them, and we don't have the. I'm repeating what I was told.
Sure.
About it.
Chairman, and he's requesting it to go to local and consent.
No.
No.
Oh yeah, he did request that. I'm sorry.
And that would require unanimous.
He did. Yeah.
Okay.
So,
And I don't want to prevent that
no.
happening.
Well, let's get him in here. and we'll ask her.
I apologize.
That's all right. So the chair withdraws the consideration of House Bill 2946 and leaves it matter pending business. And if there's no further business of the committee, House Committee on Juvenile Justice and Family Issues stands adjourned at the calling of the chair.